Well, hello, everybody, and welcome back to Raw Law Unfiltered with your host, the DUI Guy Plus. Folks, today we are going to continue with the Sarah Boone suitcase murder trial. For those of you who have not been following along, allow me to tell you that this has been a very, very heavy case. I mean, there is so much callousness that we see from Sarah, and there is so much pain that we feel for George. And the more we see, the more we feel for George, and the more, at least me personally, I'm beginning to dislike Sarah. And I can understand why she has been such a difficult client to begin with, and why she has gone through so many attorneys. Because every attorney is like, "Look, woman, you are a horrific person. A jury's going to take one look at you and listen to the evidence and is going to go, guilty. Like, no question." And she's like, "No, I am innocent. Battered woman's syndrome or battered spouse syndrome." So I don't blame attorneys for having constantly walking away from her, or her being, firing her attorneys or whatever. So I want to start, folks. I think court is going to start in like 2 minutes, but they're just going to be doing jury instruction stuff. I don't really care about that as much. I think they agreed to appear at 8:30 because I watched the end of it. But I heard that the cell phone footage is where we get to see the real Sarah, and that I have to watch it. Somebody was like, "Larry, you have to watch this." So I'm gonna put this at I don't know, maybe 1.5 speed is too much, maybe 1.25. I'll try 1.5. If it gets too much, we'll go down to 1.25. But I just don't have a whole lot of time. We only have 30 minutes. 30 minutes to go through. Well, 30 minutes to go through 30 minutes of footage, but also obviously with commentary.
5 p.m.
Whenever you leave the house, just let me know where you're going.
And you're gonna let me leave.
Yes. Just let me know where you're going.
And I get to leave the house.
Yes.
Exit.
Just let me know where you're going, so at least I know where you're at.
Anything else to like to add?
I love you.
So it's not yank me back in the house and sit the fuck down and shut the fuck up?
No.
Yank.
No. Just let me know where you're going, so I know where you're at. So if you don't come back, there's no certain time. You don't have to come home at a certain time, because I'm not. You're grown up. I just want to know that if it does surpass a certain time, that's like, shit, where's she at? I know where you told me you were going to be in. So that way I can go.
So I'm not allowed to have friends.
Yes, nobody said you can't have friends.
I can just go see Boone.
You can go see whoever. I just don't want you to go frolicking with male friends.
Reasonable.
By yourself, because you know what's happened already. You understand what I'm saying?
So I get to go see Boone.
Do you get what I'm saying?
I get to go see Boone.
I don't care about Boo. You can go to see Boo. Do you understand what I'm saying, though?
It's interesting how he is making a request of her, a very simple request, and she's just being non-responsive rather than being like, "Yes, honey, I will do this for you," or "I love you and I understand. Obviously, this means a lot to you. I can feel what you're feeling, and I'm sorry I made you feel the way that I did. And from now on, I will be sure to at least let you know where I'm at." And she's like, "I'm just going to see Boo. I'm just going to see Boo." And then when he presses, he's like, "Will you please at least tell me?" No response. No response. She does not respect.
19.
I love you.
I don't know what the fuck you talking about, dude.
Let's just tell everybody you got crumpled on the bed.
Crumpled? Crumpled. The word you're using is crumpled? Alright, so this is, my, jeez, you gotta put it all on my face, dude. I know you're filming me, but you gotta put it on. What the fuck is that? Stop.
Bum rushed.
Yeah, you're bumming.
I bum rushed you.
Yeah, whatever. Anyways,
What was the choice?
so the choice was to beat your ass or get my ass beat or whatever.
No.
Huh?
Twas.
Huh?
Twas.
Twat?
Twas.
I like twat. I've been trying to get twat from this woman. I've been trying to. Hurting me. The phone. I've been trying to get some of that right there. She found some of her shit. I don't know what's going on. She's trying to film me, filming her, and blah, blah, blah.
I'm cooler than you.
And she's, yeah, you are. You are cooler than me. You are cooler than me. She is cooler than me. She is beyond cooler than me.
Oh, I want to get this on tape. Did I take you serious today?
No.
Did I take you serious to the beach?
No.
Then who was my mom?
You. I blame it on you. Sorry. I apologize. Can I walk around this way and actually film it better? I don't want darkness because you're not dark. There she goes. There she goes. What are you filming? You filming me, filming you? You filming me, filming you?
What's the latest thing you've done me wrong by?
Man, I watched porno. Hey. Wait. It stopped.
My husband.
What's up? I was watching porno. She don't like that. I'm not shrugging my shoulders or anything like that. Like it's not no big deal.
After you begged and pled and cried,
Yeah.
we trust you.
I know. I'm not shrugging my.
Say it. Beg,
Yes.
pled, cried.
You begged.
I didn't. You did.
Well, whatever. I know. Okay. Yeah, I did.
Say it.
I begged and
Pled
pled
and cried
and cried
for me to trust you.
for you to trust me. But again, I'm not
Did
sure.
you?
Did I watch porno again? Yes, I did. But
Good.
Next is a video starting with 3BB0C. Metadata shows date modified 12/29, 12:36 p.m.
So you remember this. Are you drunk right now?
no, man,
How much alcohol did you drink?
enough. You know?
You're slurring your words. You're sleeping up against the door right now.
Yeah, because I want to be next to you.
Did I not tell you to not bother me?
Yes, man.
So what is it you come up and do? What time is it right now? It's 1:20 a.m.
He's treating like a child again.
I don't mind you. I haven't bothered you since then. I just fell asleep.
But didn't I tell you before at 9:30 to not bother me at all?
Yes.
Because why?
Yeah, so what's wrong?
No. Because I've been up since 4 a.m. since yesterday when you fucked with me.
Yes, ma'am.
I know how much vodka was in that bottle. And what's the bottle now?
Kind of to throw it out.
What does that mean?
One more drink.
The bottle's empty. I know how much vodka was in there. And then for two people to have a really good time. And who drank it? I want it to be documented that I'm leaving you, which means that you're getting out. You're getting out. You're getting out.
I want it to be documented that I am leaving you. Who talks like that? What human being talks like that and just continues recording? Just be like, look, man, I'm out. No, I want it to be documented that I am leaving you as she's recording him. This is not normal human behavior. She's definitely got a few screws loose. I think we already kind of gathered that, but this is more evidence to pile on.
Even nobody stop.
And the reason why you were even downstairs and weak enough to get drunk was because you don't give a shit about me. You don't listen to what I say. Special things that I keep on my front page of my phone, so I remember to tell you about it because of how special and fun it is. I always bother you. I always bore you. You don't listen to me. Yesterday was my first day at work, remember? And I ended up 90% hearing about your day and 10% about mine.
You don't bother me or anything. So sometimes you just you overwhelm me. That's the problem. You overwhelm me.
I tell you about my first day at work.
No, dude, you just overwhelm me about every other thing too. Not just, first day at work.
So I'm overwhelming you by telling you about the fourth highest paid baseball player. That's a client of ours.
I'm not starstruck.
I don't even know who the guy is.
I don't need.
So the reason why, so you fully admit now that you didn't care and you did brush me off in the car, midway sentence, because you're not into baseball.
No, I mean, I'm just saying.
I want to go to sleep. Go downstairs.
Okay, yeah. I know.
I'm leaving you, and I'm going to try and cancel plane tickets.
No.
Because I don't do special things for people like you that are doing this, like, to me, after I asked you at 1:21 in the morning. I wanted to be asleep. I wanted to stay asleep, which is why I got into bed at 8.
At 1:21 in the morning, I told you that I want to go to sleep. I don't know about you all, but is anyone else struck by that phrase especially? She's like a Judge DeThomas's type. At 1:21 in the morning, I told you I want to go to sleep. Not like it was around 1 a.m. No, it was 1:21. Like the specificity. That's terrifying.
8:30. I told you not to step foot in the bedroom. So what do? Nonetheless, you're drunk. The amount of alcohol, I know how much is alcohol. I know how much it is.
I was trying to answer. She won't let him.
That's why I could smell you in the bed before you actually got me up. I can smell you from here. You're despicable.
You're no better.
I'm not expecting. I'm not even doing anything.
Leave me alone.
Okay.
You're not gonna remember shit. Okay,
Yeah, okay. Well, I'm not doing nothing right now.
get away from me. Get away from me.
I'm not doing nothing to you.
You do everything to me all the time. All the time. Heartache and pain is what you cause me. Heartache and pain.
Okay.
Keep going. And I dare you. I dare you. I dare you. You get on your fucking little bike and go to fucking work tomorrow. Don't look at me. Don't come close to me. Don't touch me. Do you understand?
What do you mean?
As of this moment, and until I can get you out,
Get the fuck out of
you're
here.
okay. I dare you. Yep, look at it. Like, get away from me. Get away from me. Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder. I will scream bloody murder. Get away from me. I'm
Nobody's doing
gonna
anything.
fucking hurt you.
Nobody's doing anything. And you're filming it.
Let me go.
Nobody's doing
I'm asking you, George, to get away from me. Please get away from me. Get away from me.
Yeah, I am. That was your function, dude. Malfunction. No, your malfunction is you, dude.
Okay, whatever you say. Whatever you say. Holy shit, the whole hallway just reeks of you up here. First it's shit, now it's alcohol.
She tells him to leave, and then she just chases after him and says more words. Like, what an ass. If you want him to leave, then let him leave. He's trying to leave. You won't let him. You're keeping him there by constantly continuing to berate him. She's getting off on this. No question. Oh, no question.
Don't step foot in this bedroom. I can't even
Leave
breathe. Like,
back,
it's
leave
disgusting.
That's all she's doing.
Like, it's disgusting.
Keep filming and that's what you want. Then I said, love you.
I don't love you. I don't like you. I don't want to be with you.
No Hindenburg situation, no Titanic situation, okay? So it's gonna be a good day. Yes, I'm missing my mustache right now. And later on, everything's gonna go off. Truth, facts. Truth and facts. All of this is gonna be missing later on. We'll take another video again later on when it happens. Love y'all, whoever watches this video.
No, that's not approved.
The FBA says it's approved.
So it's gonna be a good day all day,
Yes, it is. Even when
All
I
day.
shave all of this.
all day,
Yes, even when I shave all of this
all
off.
day.
It's gonna be an amazing day.
It's what time right now?
Shaboing
I'm
boing.
gonna say 9:30, 10 o'clock maybe.
Shaboing boing. That's what we're doing later on. Shaboing boing. You can stop filming now.
It's not good enough.
It's gonna be a great day. Today's a great day to have a great day. Boom. Cut. Somebody come in with a. Can somebody come in with a. Can you not?
09.
It's 6:13 and I asked him not to play with it. Cause I told him that I was gonna go to shit. Time.
Sirens. 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 Sirens and sirens and sirens. And this cop car.
How about you get an umbrella and call me Camille underneath it?
You know, how about we forget about that? No, we won't.
I'll never be.
How about we keep going on? Okay, how about this? When beautiful Lucas is here, we don't listen to none of that. I don't want to hear sirens. It's just beep, 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 all that, whatever. I want to listen to that. It's every single day. Beeping and we hear enough of it out here in reality.
Are you gonna be nice tonight?
Yes. Yes. I promise you. It's the truth.
Go for a walk.
By myself?
Yes,
No.
go for a walk.
She's ordering him to
Chill
take a
out.
walk.
If that's the case, I'll just chill out.
Oh,
So much, like, it's-
so hard to watch.
Don't ever be a woman.
how can I be a woman?
Don't ever.
I can't. But I can, somewhat understand.
Don't ever.
I can somewhat understand. Somewhat understand. I can somewhat understand, yes, where you're coming from. But when you have a child and it's like right now, this is too much. But we had a blast with him. Amazing.
Then you got out of sorts and pushed me, and he stole my phone and told Brent.
Why is it that I got out of sorts?
You pushed me.
I pushed you. I didn't push you. How do I get out of sorts all of a sudden? I don't want to hear it.
You drink too much and you're upset.
Thanks so much.
Go get your fuck card shit.
What are you talking about?
Your retard paper. Don't hit women.
Wow.
Have I hit you? No. So where are you going with this?
I'm turning this off.
Tell me whatever else you have off. I get it. You can film me, take a picture, or whatever you want.
You can tell you're on my
I'm not doing
Do I forget about it? No, I don't.
I'm not doing anything to you.
No, I never do.
I'm not doing anything to you. Sarah.
That's my name. Don't wear it out.
Sarita. I'm not doing anything to you.
Yeah.
It's not a yet. I will not.
Mr. J.
It is 5:28, and we have 3 minutes and 49 seconds of videos if the jury is capable of staying. Date mod.
Hi, my fan. This is what happens. I'm going upstairs to ask for where my car keys are. Because it takes a little time. Where are my car keys? Where are my car keys? Where are my car keys?
Where are you? Where are you always at? What are you talking
No, they're not. You took them.
about? Sarah, I didn't see your car keys.
Where are my car keys?
Where you at? All the time. What in the world are you talking about? They're in the, they're there with it.
No, they're not.
Sarah. They're at the,
No, they're not. You took them. And watch you walk away with them.
why would I take your freaking car keys?
Oh, you're not gonna curse now?
What are you talking about?
You took my car keys.
I didn't take your car keys.
You did.
Twelve 29 2000.
I'm gonna go to court and I'm gonna tell the judge, listen, my fiance has nothing to do with it. It's all my fault. We were both drinking and got out of hand. Isolated situation, it has never happened before. I love my fiance. She's a good woman. Never been in trouble in her life. She has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind, one is deaf.
Oh my God. She's coaching him how to testify in court and recording him doing that. Oh my God. That's how far their relationship has gone. Wow. Yeah, all this was being played to the jury yesterday evening.
She goes around and she's driving and sees an animal that's injured. She'll stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than where it already has. We both love each other. We both live together. Yes, every relationship has their arguments, but we are not the type of people that you guys are trained us to be.
She
Especially her. So please, if you can,
dismissed,
dismiss this case,
closed,
drop it. She is not the type of person.
good person.
Oh, because now she had charges against her. This is when she was arrested and charges were also levied against her. So she's trying to maintain a clean, perfect record, like the perfect little angel that she is, and she is getting George to do her bidding for her. Wow.
She's a great person.
Angel.
I know she'd be an angel. She's close to it.
Best thing that has ever happened to you.
Yes, ma'am. I love you to death. And I hate that we're going through this.
It's on it.
What?
And it did.
You're good. I love you, baby. Whatever you want to say. God will prevail, and He will take us out of this situation. Love you.
That'll be it for today, Judge.
All right. Get your noise back up.
There's more this morning, folks. This is today. So that was yesterday. This is court right now.
Fine by me.
They're doing jury stuff. Wait, what'd they say?
Excuse me, Judge.
Yes, sir.
Can I have Ms. Henderson explain how she sent the document?
Fine by me.
Yesterday morning, and then last night we approached and I had asked if that format was okay for you. I believe Mr. J had said, could the defense send separate 3.6, 3.F, so it'd be easy to incorporate in your final instruction.
And that's what was sent at 12:05 last night. All right.
Just for more convenience for you.
Understood. Okay.
Thank you.
But the balance of the instructions, because that just addresses those.
I'm sorry.
What you just advised only speaks to the 3.6, 3.6G instructions.
And F and culpable negligence.
Correct. Okay. All right. So I'm talking about the balance of the instructions that may or may not be at issue.
Yes, sir. That was the balance of instructions that are not at issue. Those are what was sent in 11:30.
Okay. All right.
My confusion is the court is indicating they have a 34.
Okay, they're just doing jury instruction stuff. That was so painful to watch, folks. That was so painful to watch. I mean, oh my God. What a poor guy. I still have not seen the Suitcase video. Unless they play it today. I'm sorry, I refuse. If they play it today, I'll watch it. But like, I swear to God. She is a horrible, and she videoed all of that stuff. People were saying like she's an Amber 2.0 or something. Maybe. I don't know. I don't think you can compare abuse, but you can't really compare abuse, but I mean, there are probably some certain character traits, like the gaslighting, the playing the victim card when you're clearly the aggressor. He was at one point he was sleeping in the doorway. She admitted she woke him up. He's intoxicated. Okay, is she mad that he drank some of her liquor because she's an alcoholic herself and she was going to drink that? She felt deprived. Now she has to spend more money to get more booze, and she can't get as drunk as she wants. So she's upset at him that he was mooching off her alcohol. Amber was more of a psychological deviant. Like she would be like, no, but Johnny, but I love you. I mean, Sarah kind of did that too. Maybe not in these videos, but previously, like, I love you, George. You know, she was screaming at him when he was like already in the back of the police car. She learned how to weaponize the system against him, like we talked about yesterday. And I think once that initial arrest happened, she was like, well, I can just keep this cycle of arrests coming and use that to control. Like, remember that one 911 call we listened to yesterday? 911, what's your emergency? Well, I don't have an emergency per se. I don't have an emergency exactly, she responds. Do you need a deputy? No. So, yeah. It's just complete and utter waste of taxpayer resources for her little gains. She likes the attention. She likes to be the centerpiece. Clearly, I mean, with that flyer, you guys remember the flyer? I'm going to show you guys again. This is just bonkers, yo. Check this out. This is the flyer that Sarah used to find an attorney. Inmate seeks attorney. Are you looking for a prosperous challenge? Are you, this is number 2, nothing to do with innocence or representing a person who has committed a crime. Are you ready for your close-up on national television? Are you zealous with a side of keen? What does that even mean? Okay, zealous advocate and also a little keen on what? Like some spicy facts with a very difficult case that you're likely going to lose? What is she talking about here? Show the world, capital letters. This is her arts and crafts coming to life, folks. Show the world who you are with your extraordinary creativity, or I'm sorry, I mixed those two. Original creativity, extraordinary expertise, confident, ingenuity. Who uses these words? Yeah, she feels like it's a game show, doesn't she? Qualifications must include being trustworthy, honest, passion-driven, open-minded, with exceptional problem-solving skills, client inclusion at all times, team orientation, and collaboration. So basically, I am going to be informed every step of the way, no surprises. That should go without saying, but okay, Sarah. Extreme efficiency in listening, communicating, and understanding, because I'm a problematic client and you're going to have trouble with me, is what she's really saying. Somebody wrote, must bring crayons. My God. Okay, that's kind of funny. Dedication to success and possessing a winning mindset. No losers are allowed. No guilty pleas. Trial only, and you have to win. If not, I'm going to sue your ass. Capability of excellence in representation. Committed. Maintaining faith. You have to believe in God and in the client. and my case with the ability to think differently. So forget the facts. The facts are terrible. Try and win, using fancy lawyer tricks, and overcome all circumstances because I have terrible evidence. Epic opportunity awaits. I swear to God, this is some Hollywood BS. Sarah Boone, inmate number, Orange County Corrections. And let's not forget the most important piece at the bottom. A little jingle she created. Invest in the oppressed. Believe. Yeah, it straight up looks like an ad for us. We could have that music playing in the background. Looking for a prosperous challenge, ready for your close-up. Are you zealous with the sight of keen? And show the world who you are with original creativity, extraordinary expertise. All right, I'm done. That's literally that's exactly what I'm feeling too. So terrible. Absolutely terrible. You're right, Kat. Amber didn't kill him, but given the opportunity, that she would have driven and past that. I wouldn't put it past Amber. I wouldn't put it past her. They're still doing
Defense, any objection to the form of the instruction?
No objection.
And also the removal of the lesser included chart on page 5 of 34, correct?
Correct.
Moving to page 6 of 34, instruction 3.4, when there are lesser included crimes or attempts. My only question is, if I understand from the defense, they're looking to see culpable negligence is a lesser included.
Yes, Your Honor.
Would that not need to be included here?
Yes, Your Honor.
Okay, so is the only addition to this, the balance of the 3.4 instruction would be correct with the exception of the last sentence, which would read the lesser crimes, plural, indicated in the definition of second degree murder is manslaughter and followed by culpable negligence.
Yes, so it should go to R. Yes.
State?
State objects, there's no evidence to support a misdemeanor culpable negligence lesser included offense for a category 2 lesser to be included in the jury instructions. Both must be supported by the charging instrument as well as the evidence in the case. There is no evidence in this case that he only suffered culpable negligence. The crime for culpable negligence with death is manslaughter. Culpable negligence isn't even a category 1 lesser of manslaughter, it's a category 2 lesser, which includes, by inference, there must be some evidence that her culpable negligence did not result in death.
What's your response to that?
Judge, the instruction that we're asking for is 8.9. It reads to prove the crime of culpable negligence. The state must prove the following 2 elements beyond a reasonable doubt. 1, Sarah Boone exposed Jorge Torres Jr. to personal injury. And 2, she did so through culpable negligence. As to the fact that there is evidence of culpable negligence as to the case in the fact that Ms. Boone, while Mr. Torres is still in the suitcase, goes upstairs. As to it being charged, it's a category 2 lesser included that's available to the defense. Defense can get category 2, lesser included offenses, as long as there's evidence to support the category 2. And there is evidence in this case to support the category 2 lesser included. That's
And-
why we're asking.
Any other further argument, Mr. J?
No, Your Honor, thank you.
Okay, all right. At this point in time, the court is inclined to include the culpable negligence as a lesser included. We'll get to the instruction momentarily. Any other revisions to the 3.4 instruction, defense?
No, Your Honor.
Moving now to 7.7 manslaughter, there are some objections. The defense is now objecting to paragraph 2C, the death of George Torres was caused by the culpable negligence of Sarah Boone. So how could you ask for a culpable negligence instruction and then object to 2C in the manslaughter instruction? Logically having trouble understanding that.
Because this is my argument, because I'm not arguing that there isn't evidence of it, because I just said there's evidence of culpable negligence. The difference is, and I think the burden is different from the state.
It might go to the
because
jury this
it's
afternoon.
not alleged in their information.
Does not the instruction say give 2A, 2B, and or
We're talking
2C
about-
depending upon allegations and
Those things
proof?
this afternoon.
Yes, the allegations would be the information.
Any response, Mr. J?
Judge, it's a category 1.
I think the case is going to be open today.
All the theories are included in that.
The jury will start deliberating tonight.
Included in the charging instrument. And quite frankly, it's not inconsistent with the language in the charging instrument. She's accused of having a depraved mind when killing him, and what the evidence has also shown is that she was heavily intoxicated when she made this decision. That supports a conclusion for a trier of fact to reach that this was out of culpable negligence, and if they reject our argument that it was done knowingly and out of hatred, ill spite, etc.
Any other argument, sir?
No other argument.
At this point in time, the court is going to overrule the defense's objection as to the objection to 2C in the manslaughter instruction, including the final 2 paragraphs
No comments.
of what the definition of culpable negligence is on the bottom of page 7 of 34. It seems like it's stipulated between the parties that 2B, Sarah Boone intentionally procured an act that caused the death of George Boone, should be George Torres, is not applicable. Is that correct, state? Is that correct, defense? Okay, thank you. And also, since 2B is not applicable, the to procure definition will not be provided. Any other questions regarding the 7.7 instruction?
No, Your Honor.
No objection to what they suggest is the definition of culpable negligence as the court's included.
With regard to the
Second lesser?
second lesser? Yeah, thank
No
you.
objection to that proposed instruction.
All right, very good. Thank you very much. What is the instruction number for the culpable negligence instruction? I think it's 8.9, isn't it?
8.9.
Okay, thank you very much. Moving now to page 10 of 34, 3.6D, voluntary intoxication. Does this now need to address culpable negligence? Or is that only?
No, yeah, we would request to add it, the culpable negligence, since it's going to be given, so it should read second degree murder, comma, manslaughter, comma, or culpable negligence.
You're talking in the last sentence, correct? Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence.
Yes,
correct?
Your Honor.
Thank you. Any objection,
No,
defense?
I agree with that.
Thank you. Do we want to take an attempt to address the 3.6F?
I would suggest we do that later and see if we can just get not
This-
3.6 cents.
At this time, just going to make a note that we're going to bypass the 3.6F instruction and 3.6G instruction. That'll take us all the way to page 23 of 34, instruction 3.7, plea of not guilty, reasonable doubt, and burden of proof. Any objection to the form of this instruction, defense?
No objection.
Moving now to page 24 of 34. Weighing the evidence, 3.9 instruction.
Should we go to 3.7, plead not guilty?
Did I skip it?
Yes, sir, page 23 to 34.
I'm sorry, I thought that's what we just covered, Mr. J. I apologize.
Oh, I didn't, I was just making sure that there were no edits that either the court made or the defense made, so I was scrolling, but no objection to 3.7.
Okay, thank you. Moving now to page 24 of 34, 3.9, weighing the evidence. Looks like give as applicable paragraphs 6, 7, 9, and 10 have been struck. Is that acceptable? State.
Yes, Your Honor, I agree that 8, the inconsistent statement instruction should get bumped up to 6.
Agreed.
And the remainder should not be read.
With those revisions, is that instruction 3.9 acceptable to the defense?
Yes, Your Honor.
Moving now to page 25 of 34, the latter portion of the 3.9 instruction. Any objection to the language contained on this page? State.
No, sir.
Defense.
No, Your Honor.
Moving now, the 3.9A instruction was struck by virtue of Ms. Boone testifying in this matter, so that need not be addressed. The 3.9B defendant's statement instruction also included the requested language by the state. Is there any objection to the form of this instruction at this time? Defense.
No, Your Honor.
Okay, Ms. Boone, earlier this week, and I can't recall if it was yesterday or the day before, the state had filed a motion seeking to add additional language to this instruction. And I had read that language to you at that time. Do you want me to read it again to you this morning? Okay, so I'm going to read you the entire 3.9B instruction. 3.9B defendant's statements reads, a statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1, whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get him to make it. That should be revised to the feminine. Any objection?
No, Your Honor.
Defense?
No, no, Your Honor.
That is the form instruction created by the Florida Supreme Court, ma'am. What has been added is the next paragraph, which reads, law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Similar to other conversations we've had this past week, ma'am, I don't want to know about specifics of any conversations that you had with you and your attorneys, just simply whether or not those conversations have been had. Did you and your lawyers discuss the proposed language that I just read to you?
Yes.
Do you have any questions with regard to that proposed language?
No.
Are you in agreement with this additional language being added to this defense?
Yes.
All right, thank you, or to this instruction rather. Thank you. The last sentence read, if you conclude the defendant's out-of-court statement, was not freely and voluntarily made, you should disregard it. Any other clarifications to that instruction statement?
No, Your Honor, thank you.
Defense?
Judge, in looking at it, it says in the final part, consider whether the defendant's statements, can we replace and put whether Sarah Boone's statements?
Where are we specifically, sir?
In the state special that I have no objection to, it says, this is however one of the factors you may consider whether the defendant's statements, if we could have Sarah Boone's statements, were voluntarily made.
The language used all throughout the instruction is the defendant.
Yeah, I tend to agree with the state on that.
Okay.
Rule 3.10, or I'm sorry, instruction 3.10, rules for deliberation, page 28 of 34. Looks like the parties agree that paragraph 7 is not applicable.
Yes, sir.
I agree.
All right, that would change paragraph 8 to 7. Any other revisions to 3.10? Defense?
None from the defense.
Moving to 3.11, cautionary instruction. Defense?
No objection.
The court then interlineated on page 30, the 2.7 closing argument form instruction. Any objection to that instruction, state? Defense?
No, Your Honor.
Moving now to 3.12 verdict instruction, page 31 of 34, state?
No objection.
Defense?
No objection.
Moving now to 32 of 34, instruction 3.13, submitting case to jury. The only other question I have for the parties is with regard to, I believe it was Exhibit A, the suitcase. Are we going to send that back, or is that going to be viewable upon writing similar to the baseball bat?
No reason that it can't be sent back.
Okay, agreed?
Agree.
Okay, all right. Is this instruction acceptable to the state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Very good. And then moving to, that concludes the, except for the 3.6F and 3.6G instruction, that includes the verdict or the instructions. I'll have Anita clean that up and send it to the parties so that we have a cleaner red line to work with. The only other question that I think we can address this morning is the verdict form. I received the defense's verdict form. And it looks like manslaughter is no longer being sought in the verdict form. Manslaughter was struck out and it was just culpable negligence.
Under the defense's part, yes.
Right.
Yes,
Okay.
Your Honor.
So how do we want to address the verdict form then? Because if we're giving instructions on manslaughter, certainly needs to be included in the verdict form.
I understand, Judge, but the defense isn't requesting manslaughter, but if it's instructed, it has to be in the verdict.
So the verdict form would read, we, the jury, find the defendant guilty of murder in the second degree as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant guilty of the lesser included offense of culpable negligence. We, the jury, find the defendant not guilty. Is that acceptable to the state?
Yes, Your
Is that acceptable to the defense?
Yes,
All
Your
right. Similarly, I'll have Ms. Barrios make those revisions and
Okay.
submit them to the parties
Yeah,
as soon
three
as possible.
potential culpable.
Anything else, state, we need to address before, Bruce, do we have everybody? As of this time?
Are culpable.
Everybody's here? Thank you, sir. Other than the 3.6 instructions and the state's request for other instructions, which I think we'll have to table for now,
Yes, sir.
are we prepared to go ahead and bring in our jury at this time?
Only thing I wanted to bring to the court and the defendant's attention was apparently yesterday at lunch, there was some sort of domestic violence event out in the quad. The coworker indicated that without believing it was any particular jurors in this case, that he did see people with juror badges in and about the area. So I don't know if that warrants inquiry by anybody.
Defense?
I think it should be mentioned.
I agree.
Okay.
I agree.
Just to see,
Sure.
we spent all this time, we've got a bunch of alternates. Let's utilize them, but I do have an issue.
Yes. What do we got?
I think the state attorney, the last piece of evidence is they extracted from Sarah Boone's phone a bunch of pages of text messages. And I believe their intent is to introduce all those text messages, which are quite a few, but I think they want to read specifically out a few to the jury. My only concern is I don't know which ones they're going to read out. And under the rule of completeness, if there's a thread where it needs to be put in context, we would ask that all of that be read. So I don't know exactly what they're doing.
Mr. J, any response?
It's going back with them, just like I told them during some of the body worn cameras. Only some of it's published. It's all going to be there for them to use. I do not intend on reading all 108 pages. I don't intend on trying to delineate what contextually is one conversation from the other. I think it's just fair to say this is all going back with you. You're gonna have a scrub laptop. You're gonna do review it all.
Mr. Owens, you can make any objections you deem necessary at the time, and we'll address it. Because it's just hard for me to say what should or should not be. I understand the state's position, but if it's something that's you believe in the rule of completeness should be provided at that time, regardless of it going back, we'll address it.
It's gonna be about 40 minutes worth of reading text messages. Are we gonna have some people come in to read the messages?
Again, I'm not sure how long it's gonna take. I did not practice reading what I'm going to be reading in the mirror. Number two, no, I don't understand why a witness would be called. It's in evidence. The lawyers do not publish them.
Anything further, Mr. Owens? Okay, all right.
Not on that issue. I would like to take like 5 minutes to use the bathroom.
Sure, we can do that. Okay, so I don't want to highlight that it was a domestic violence event. So are the parties, is it acceptable to the parties to inquire of if anyone heard or participated, got any information, or observed anything of the event that transpired yesterday afternoon in the courtyard? Is that acceptable?
Yeah, you definitely shouldn't suggest what.
Agreed. Okay, got a thumbs up from Mr. Owens. All right, we'll take a 10-minute recess. We'll just plan on bringing back here at 9:30. We'll bring the jury in at that time. Thank you all very much.
Okay. So I did some research and I want to fill you guys in. Let me just finish getting all this stuff for you. What's the minimum though? So, okay. I can't find the minimum, but here it is. So they're going to charge the jury, they're going to instruct the jury on 4 different instructions. 3 of them constitute guilt, 1 of them does not. So the first is murder in the second degree. If the jury finds her guilty in the murder in the second degree, the judge can issue a sentence ranging from 16 years and 3 months in prison minimum, bare minimum, to life. Number 2, the jury can find her guilty under the second instruction, manslaughter in the second degree, in which case the judge will issue a punishment ranging from 9 years and 4 months minimum up to 15 years maximum. If the jury does not find her guilty on murder in the second degree and does not find her guilty under manslaughter in the second degree, they can find her guilty under something called felony culpable negligence. Culpable negligence that is felonious in Florida. I can't find the minimum on that for some reason. I don't know if it's like a year or 2 or something like that. Maybe if I can find the statute. Because there's a death involved. Because culpable negligence is obviously a broad statute, and it covers it covers like if there were injuries or not. Because sometimes you can be negligent, but there are no injuries. Sometimes you're negligent and there are injuries, and sometimes you're negligent and there's a death. And each and every single one of those carries a different sentence, obviously. But I believe it's up to 5 years under culpable negligence. But I don't know if the jury's going to know any of these numbers. Because what I'm seeing is when it's a felony, when it's like a firearm being used under culpable negligence, most of them treat them as a misdemeanor, and that is like 1 year. I don't know. Let's do a poll. Let's do a poll. I'm curious. I'm interested to see what people are thinking. Okay. Um, all right, let's start a poll. Let's see if chat and Twitter can figure out what the jury is going to vote and how the jury is going to vote and if this is going to be accurate. Not accurate, but like mirroring what is actually going to happen in this case. People want her to fry. Wow. Everyone is saying murder based on her behavior. It's crazy. Go and vote in the poll. There's a poll on Twitter and there's a poll to the left of me or right of me, depending on how you want to. The vast majority, Thomas, the vast majority of people The overwhelming majority. 70% right now. It's a very unusual case. Definitely not something we're going to see very often. They're about to bring the jury back in. When the court gets back in session, they're going to bring the jury back in, and the state is going to finish playing the videos. I mean, we haven't even gotten to the day of video, the February 24th, 2020. I think not guilty is not possible. Not guilty is not possible. She has some level of culpability. I think that's a given. So I can eliminate that personally right away, right? As to the other three, culpable negligence just seems like a cop-out. It's too light, you know? It's like culpable negligence. It's like, oopsie daisy. I think the jury is gonna walk in and they're gonna work backwards. Like, how many people think not guilty? And they're gonna count the hands or whatever, the notes. They're gonna do a vote right out of the gate. That's how jurors usually operate, because they want to know where everyone is at. And I think all 6 people are gonna be like, no, she has some level of culpability. Then they're gonna be like, okay, what do we think? Culpable negligence. Does she have any culpability here? Yes. Does it go beyond negligence? Do we have any sort of intent? You know, how many people think she was just negligent? Maybe one person will raise their hand. And the rest will be like, no, I think it was intentional or something like that. And then they'll go to the next one. You know, let's jump over to murder. Like, how many people think she actually like intentionally murdered him, right? Like, what is the actual definition of murder to? In Florida, second-degree murder is the unlawful killing of another person without premeditation, but with a depraved mind and an indifference to human life. What about manslaughter too? Intended to cause harm, but without premeditation, caused the death of another person, did so of committing a non-felony crime, or did it through culpable negligence. So there it is. Culpable negligence is still there. Yeah, I think the jury is going to vote manslaughter too, folks. I don't think they're going to go for murder. They might, but her act seems like it was more, she was negligent, she didn't care. But if they dislike her enough, here's the thing, here's the key. If they dislike her enough, they will give her murder too, because they're going to want her to go away for a while. They are going to want her to go away for a while if they don't really like, after watching yesterday's videos, they might. They might go for murder too. But all 6 of them have to agree, remember. All 6 have to agree.
You all can be seated. Thank you. All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for counsel, starting with counsel for the state.
Steve Castro on behalf of the state.
William J. for the state.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Ms. Boone is still seated at counsel's table. Are we ready to go ahead and bring in our jury at this time? State.
Yes, sir.
Defense.
Yes, sir.
All right, let's stand and bring in our jury.
Jury entering.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
All right, members of the jury, you can be seated. Members of the jury, good morning. Welcome back to 12 Alpha of the Orange County Courthouse. Just again, if you could raise those hands, confirm you complied with the court's instructions. All right, all hands have been raised. Thank you very much. Members of the jury, before the state continues with their evidence presentation today, I just have a couple of questions to go over with you. Yesterday, there was an event in the courtyard of the Orange County Courthouse. Did anyone happen to observe that event? If you did, please raise your hands at this time.
What do you mean by observed?
We'll get to it.
Okay.
Okay. Did anyone happen to hear anything during that event? All right. Record reflects no hands have been raised. Did anyone see anything during that event? All right. Juror number 2, first row. Thank you, ma'am. Did anyone participate in that event? Record reflect no hands have been raised. Did anyone receive any writings or review any material from that event? Record reflect no one has raised their hands. Can the parties approach?
Wait, sorry, what event? I apologize. I was distracted for a second.
Happen to hear any else? Did anyone happen to? Yesterday, there was an event in the courtyard of the Orange County Courthouse. Did anyone happen to observe that event? If you did, please raise your hands at this time.
Event.
What do you mean by observed?
We'll get to it.
Okay.
Okay. Did anyone happen to hear anything during that event? All right. Record reflects no hands have been raised. Members of the jury, I'm going to send everyone out except for juror number 2 in the first row. We've got a couple follow-up questions for you individually, ma'am. Same instruction I've given you all previously. Please don't conduct any independent investigation or research as to the person, places, things, or charge involved, and don't have any discussions amongst yourselves or anyone else, and we'll bring you back in as promptly as possible. Thank you. You all may be seated. Thank you. Juror in seat 2 on the first row from right to left. You had advised, based on the court's question, that you had observed something. And you said, what does observed means? And instead of getting that out in front of every other juror, we just want to have that individual conversation with you now. So tell me what it is that you saw or heard or anything yesterday in the courtyard yesterday.
When we were walking back from lunch and we saw that they were gathered, and I asked the deputy if he knew what was going on, and he said it was somebody talking about domestic violence.
Okay. And you said we were walking. Who's we?
Another juror. I don't want to say her name.
Okay. All right. Is that a juror that was on our panel here?
Yes.
Okay. All right. Do you recall where they may have been seated?
No, in the back over there.
Okay. Do you recall what color her hair was?
Yes.
What?
You want me to tell you?
Please.
Dark brown or black?
She doesn't
Is
want
it
to
the
throw
short
it on the bus.
Juror? Okay. Thank you very much. State, any further questions?
And after you were told what was going on, then what happened?
I walked back in.
All right. Did you hear any of the speakers?
I couldn't hear anything. No.
Anything further from the defense?
Ma'am, did that affect your ability to be fair and impartial?
Can the parties approach for a moment?
Yeah, it's not going to affect anything, but that's fair. I mean, they have to discuss. They have to figure things out. Is this going to affect you in any way, shape, or form? Nah.
We appreciate you, ma'am. Thank you so much. We're going to go ahead and bring in the balance of the panel. You can just hang out where you're at, okay? We stand for you. You do not need to stand. We stand for you.
Jury entering.
State, you recognize our jury.
Yes, Your Honor.
Defense, do you recognize our jury? Yes. All right, y'all can be seated. Thank you. Again, members of the jury, if I could see those hands, you complied with the instructions during that really short break. Record reflect all hands have been raised. Thank you very much. Mr. J, you may proceed, sir.
Permission to publish from States 21, which was previously marked as P for identification.
You may proceed, sir.
Again, this is a DVD exhibit with 2 folders in the main directory. One entry is in a folder called Attachments. Another is a PDF labeled Extraction. And for the record, it is 108 pages, and the entire document will go back to the jury, and there will be a laptop provided to them to utilize this exhibit. For purposes of publication, I'm going to go by page number and date unless something requires more specificity. And for to and from, I'm going to just use the name of the contact if one exists or the phone number if one doesn't. On page 1, creation time for notes, 7:49, asking Jorge or George not to be despicable to me, making more drink after he guzzled his and I shared mine. On page 2, date March 8th, 2018. You are now in a relationship with Jorge
or George on Facebook. Metadata entry 100014, etc. for Jorge Torres to Sarah Boone, owner. Page 3, May 21st, 2019, from 407-716-8684 to Melissa. And he can still live here, correct? Or until I decide to finally get him out if he doesn't clean up his act after tomorrow. On page 9, May 30th, 2019, from a contact labeled as Mom, Jorge or George, to 407-716-8684, which I will just refer to as owner in future references. Where is my clippers in the gray box? From owner to Mom, Jorge, all capitals, dumpster, separate message, like you, separate message, so is your 2 shirts, separate message, no more Rick and Morty, a response from contact Mom Jorge to owner, okay. From owner to Mom Jorge, Lucas cried when he saw the adventure fund was gone, thank you, no wonder you're out, fuck off. From owner, he's the one that broke it because you took it. From owner, wanted to go on an adventure. On to page 10. From owner, be proud, feel good. You made my, quote unquote, our son cry. Cheese stick, Lucas, your kids, get the fuck out of my life and my son's. No one. Spinster, good, for nothing, dumpster diver, that's what you are, and the rest of you. Later on this same page, owner to Mom Jorge, get all of you, mean, selfish, fuck all you, your firstborn is a joke. Going on to page 11, same date of May 30th, 2019, from owner to Mom Jorge, get the fuck out of my life. Lucas 2, bad influence. From Jorge to owner, I am, as you can see, go drink your life away. From owner to Mom Jorge, your kids are too. Yuck. Shucks, I only have 1. Beaters, your 3 together. Yuck. Going on to page 12, from owner to Mom Jorge, still dated 5/30/2019. Gross, and all the time, gross. Mom Jorge to owner, I love that guy. You're the one who kicked me out. Owner to Jorge, Mom, finally. Get your shot together and check me out in 2 to 3 months. Hope you're there. Unless I find someone better. Shit. Together. From Mom Jorge to owner. Are you serious? Owner to Mom Jorge. That's what happens? No. Mom Jorge to owner. I'm helping out Dad right now. Call you in a few. Owner to Mom Jorge, can you help me put out, fuck off? Jorge, Mom to owner, how? No problem. From 267 216-5170 to owner. Damn, you can only talk when you're drunk and talking shit. Owner to the previously mentioned 267 number. Stop calling, texting my phone. He's not here anymore. And it's damn. 267 number to owner. NP, you didn't have to be a bitch about it. Owner to 267. Going on to page 13. Still May 30th, 2019. Yo, I like you all. He's a dick and the sheriff just left. Sorry I couldn't text back. I'll always respect you all. You know that. He's not here anymore. And yes, I am a bitch. So are you. 267 to owner. Look, I'm not here to be taking shots at you. I never called you a bitch. I said you were acting like one. I'm not going to be here going back and forth on some childish shit. Have a good night. Owner to the 267 number. Friends forever, thank you. Would love to chat sometime. Call his parents, I guess. Further down on page 13, now on to May 31st, 2019, from owner to mom, Jorge. Tell Jorge to call me. I want my things he took. I have his birth certificate and propane certificate until then if he wants those back. And I have your quote unquote art box. Mom Jorge to owner, stop being petty. I did not take anything that wasn't mine, I swear. Owner to mom Jorge, you're a liar. I never can believe you from all the other lies. You stop being petty and take shit like you always do. Another one bites the dust, Jorge. Hope you're miserable like you've made everyone else. Mom Jorge to owner, I'm not lying. Owner to mom Jorge, Lucas said he won't miss you either. When I get mine back, you'll get yours. Mom Jorge to owner, I didn't take it. I'm coming over in a few to get my stuff, and I'm coming with Jean and Melissa. Going on to page 14. Owner to mom Jorge, go for it. Bring mine W. Mom Jorge to owner, I don't have anything of yours. That's why I'm coming with them so they can vary that. Owner to mom Jorge, I don't care. They're not going to babysit you because you're an asshole and got kicked out after being taken off the lease. Mom Jorge to owner, they seen what I had in my hands. Owner to mom Jorge, still don't care or believe you. I'm going to get Lucas anyway, so don't waste their time or mine. Mom Jorge to owner, exactly. Owner to mom Jorge, you were a visitor and a terrible resident, boyfriend too. Just go away unless you bring my stuff. Mom Jorge to owner, I don't have your shit, Sarah. I need my birth certificate. Owner to mom Jorge, I don't give a shit either. I worked for that birth certificate, voter's registration, and your ID card. Just because your name is on them doesn't make them yours.
What?
Even paid for them. I needed you to be a man and take care of me, not beat me, call me names, and make me feel like I'm not a person.
What?
Not giving back until I have mine.
She's holding it ransom.
Owner.
She's holding it hostage.
Sarah. Owner to mom Jorge. Next step is restraining order. Know that. You can come over here 100 times. Doesn't mean I have to open the door. Good one, Jorge. Go away. Mom Jorge to owner. Whatever. Owner to mom Jorge. It's been a great day without you. Will be from now on. Mom Jorge to owner. You need to do. Owner to mom Jorge. Enjoy living with your parents at 41 with no girlfriend and lonely. It was the inevitable, just like it has been before. Owner to Jorge, mom, did you take Lucas's sunglasses? Mom Jorge to owner, OMFG, no, I did not. Turning to June 2nd, page 15, 1:10:57 a.m. from owner to mom Jorge. Jorge, question mark, call me. If Jorge is with you, can you have him call me, please? Text to Mo. (1:18), 16 seconds on June 2nd. Owner to mom Jorge, I beat you to the punch. One, do the dartboard with me? Come. Owner to Mo, I know you won't answer, Mo. Tell him to come finish the dartboard with me, please. Owner to Mo, I miss him. Owner to mom Jorge, ask Jorge to call me, please, when he gets a minute. June 2nd, 7:43:40 a.m. Can you have Jorge call me, please, when he gets a chance if he's with you? 7:45 a.m. Owner to Mo. Going on to page 16, June 2nd, 2019, 10:50 a.m., 55 seconds. Owner to Mo. Hello. Can you please have Jorge call me? Willing to give back. Don't know if he's there or at parents. Really want to see him.
She's bipolar.
Owner to mom Jorge at 10:52, 16 a.m. Not pursuing after 12 o'clock. Ever again. (12:19 p.m., 23 seconds. Owner to mom Jorge. Please call. Come over. I'll come get you. Come over, please. I need a super hug. Hugs? Please. Need. You. 6:23 p.m. Owner to Anna. He doesn't live here anymore. Call parents or Mo in response to an incoming phone call that was made at 6:10 p.m., 54 seconds from Anna to owner. Entries 9803, 9804 in the PDF timeline, June 2nd, 2019. Image 0092.heic. Capture time 6:33:01 p.m. Image 0093 HEIC captured 6:33:26 p.m. Publishing from attachments. Image underscore 0092 metadata showing 6/2/2019, 6:33 p.m.
What did she do? I'm confused. It's just a birth certificate.
And image or IMG underscore 0093 metadata date taken 6/2/2019, 6:33 p.m.
Dude, you need to zoom out. Oh my God.
(6:34 p.m., 51 seconds, June 2nd, 2019. Outgoing from owner to mom Jorge.
What a horrible.
All up to you now, big boy. And for the record, those images were sent to mom Jorge at 6:34 p.m., 33 seconds. Look what you made me do. Or maybe your mom will for you. Response from mom Jorge to owner. Wow, that's really childish. Owner to mom Jorge, but effective. Mom Jorge to owner. Yeah, I see what you are doing. Did Lucas leave? Owner to mom Jorge. I'm watching shadows. Be gone for good. Minus birth certificate. Mom Jorge to owner. Okay, cool. Enjoy. Owner to mom Jorge. Am. Nice. You're not. And nice was from mom Jorge to owner. Going on to page 17. This is still June 2nd, 2019. Mom Jorge to owner. Yes, I am. You are not, though. Owner to Mom Jorge. To who? Your mom? Brothers? Not me. Mom Jorge to owner, to everyone. Owner to Mom Jorge, but me. Mom Jorge to owner, I love you. Owner to Mom Jorge, I'm going out at 8. Get dressed. I've given you since noon. Peace out, Boy Scout. Mom Jorge to owner, I'm coming over with a handle. I was helping Pop all day cut grass. Owner to Mom Jorge, yay you, getting in the shower then out. Bye-bye. Mom Jorge to owner.
Excuse me, can we approach the bench?
Yes.
I think the defense is getting a little uneasy because these text messages are very damning. I mean, come ripping up a birth certificate? What are you, 5?
Objections overruled.
Yeah, they're probably trying to exclude some of this stuff.
I'm already showered and dressed. Mom Jorge to owner. Hello? Text from Anna to owner. You're rude as hell, but okay. Owner to Anna. Your dad is a POS, but okay. At least you know and will stop calling. Owner to Anna. Futile. Anna to owner. CTFU as you are a piece of shit, but that's God's business, not mine. Have a good day, Coke whore. Since you like to switch it up, I'll do the same. Don't text me back either, fake ass. Page 20 of 108, June 9th, 2019, from owner to Philip. He's off the lease. The process has begun. Page 22, June 11th, 2019. Metadata only shows to Mom Jorge. You tell your son he's not welcome here, taken off the lease and bound, worthless. Don't show his ugly fucked up face around here again. Police will be called. Ask him if it was worth it and ride my bike he has. Stay Hispanic, that's what you all are.
Oh my
He
God.
can watch all the porn he wants from the phone Mom gave him.
Stay Hispanic? Ooh, racism is not a good look for you, Sarah. Also, remember, the jury might find her guilty on murder too if, they've seen the video. I still...
Page 26, June 14th, 2019, 11:38:56 p.m. To Mom Jorge. Wow, congrats. Blackouts and whoring. We wanted to see him. Hot house, 7 people. Mission to work on my bike. Repeat. Candy Crush. Fuck himself. Shit job. Repeat. Same page, June 15th, 2019, 7:37 p.m., 48 seconds. To Melissa, just an FYI, if my place gets effed up, I'm letting you know. He's in jail. Thanks for the prompts. I'm at my ex's house. Please don't let this reflect on me as a tenant. You said to call cops. I did. He's gone. We're both proud now. I consider you my friend. Melissa, why was he in your apartment? Page 38, notes, creation time, June 26, 2019, 5:56:57 a.m. 6:14, X videos, 10:03 a.m. Sarah Banks, 5:03 Bank, 6:13, Metro Activation 6:12. Skipping down, X videos, 6:02, 6:13 p.m. X videos 6:1. X videos 5:31, 9:56 a. Who's Christine? Paren FB. Going to meet up? Question. Calling her beautiful? Question. Said she thought you were avoiding her when down here. Said no, I was not beautiful. FB-nonchalant Quay. Thanks for adding me. You are exquisite. Facebook messaging Camille 6:13, 9:42. Facebook or FB Pamela Erickson sending pictures of yourself, telling her good morning 7:14, 12:13 a.m. FB Crystal going to woo her, sweep her off her feet, going to change her mind. Luck is my middle name. Sent her pics, kiss emojis, called her beautiful after returning to the convo. Said you had to pick up your brother, sent pics of beer, sent her struts, could have been me, sent her songs but not me, messaged bunny kiss emojis, convo, sent puppy kiss emoji, would love to take her out and see a movie, told her about what we do in the shadows, would love to watch Creed 2 with her, want to snuggle with her and eat popcorn, sent heart-hugging animal emoji, want to play a board game with her, asked to FaceTime call her, called her amazing, messaging at 7:30 a, 6:14, 6:15, 2 days. FB-Crystal liking all her posts, quote, losing someone who doesn't respect or appreciate you is actually a gain, not a loss. Can't compare me to the next girl because there is no competition. I'm one of a kind and that's real. Continuing on to page 39, same note. I found everything on your phone, all your messenger texts, telling Christine you want to meet up with her when she's here, calling her beautiful, thanking nonchalant Quay for adding you and calling her exquisite, telling Pamela Erickson good morning and sending pictures at 12:38 a.m., messaging Camille, then the whole 2-day convo with Crystal, how dare you, and send pictures wearing my wedding ring. You're a cheating, lying scumbag. I will never trust you. Why don't you put your mugshot up, or I will, since I have your phone and login, and tell everyone why you were in jail for the 3rd time. Let them know you beat your wife and she put you there because she couldn't take it anymore. I want nothing to do with you ever again. I've become a different person since you've been gone, with less stress, anxiety, and worry. I feel safe, comfortable, happier with you not here or seeing you at all. I can say through I do have heartbreak after going through your phone. Thank you for always proving me right. I knew when you told me your mom gave you one that you'd be back to your slimy ways. You will never change. I hope it was all worth it, all of it, including losing my debit card for the 3rd time to buy beer and cigarettes, which put you back where you belong. I know for a fact you were not worth any of it. I just can't believe after everything I've done for you, including all I did to get you out of jail, and you do this to me. This is cheating. Goes on to page 40, goes on to page 41, and ends with never truly yours. Page 42, June 26th, 2019, 8:06 p.m., 16 seconds. Outgoing from owner to Mo. Just wanted to let you know to tell Jorge I found all his messages, kissy face heart emojis with Crystal and other bitches on FB, along with all his porn after he swore to me he wasn't doing any of that anymore. I'm not doing anything more for him, and he will try and keep him in jail as long as I can. Cheating snake weasel. Ask him all about it or have your parents the next time they talk to him. I'm not anymore. So hurtful after all I've done for him. He can rot in there for all I care. Going on to page 43, to Mo from owner, and I will be there for the hearing next week and his arraignment on both charges. Peace out, fucks, AKA Torres. Same page 43, from owner to Mo, 6/26/2019, 9:59:14 p.m. Begins, hi, I was thinking if you could get out, I'd really love it if you'd take me to a movie, or we could snuggle like we do and watch Creed 2, get some popcorn and pretzels, maybe talk about what kind of other movies we like, or find a fun board game to play together. I know your favorite is Abalone. What do you think? I was also thinking the other day about how much I miss you sending me pictures of yourself throughout the day, sending me songs you wanted to hear or thought I'd like. But what I really miss are the kissy love emojis you would send, just because I really miss those, especially the ones with hearts. They'd always make me smile. I knew you were thinking about me. You do Crystal, though. Even asked her to FaceTime. What would you do if you found me having this convo with Ben or John or anyone other than you? I'd be beaten to a bloody pulp. And don't do any of these things anymore, but yet you wear your wedding ring and mine around your neck and tell me how much you love me. But you're telling this woman who looks like TPT you want to snuggle with, take out to a movie, play board games with, questions, sending music, cutesy, kissy, love emojis to like you used to me, telling her you want to woo her, sweep her off her feet. How do you think that makes me feel? Why don't you say that to me?
There's motive.
Going on through the rest of page 43, page 44, including on page 44, dirty cheat, enjoy your porn and jerking yourself off secretly so your parents don't see you and your ugly new girlfriends. I can't wait to finally be with a real man, Ben, who will and has taken care of me. Can't wait to see what he's like in bed. I already know he kisses. Hope it was all worth it. I'm free. As you told Crystal in your messenger text, you're single with a little cutesy dancing dinosaur. Wow, now you really are. You're despicable. Next text.
This is 8 months
XOXO
before she kills him.
from Mo to owner. Page 50, 6/28/2019, 10:55:47 p.m. from owner to Mo. Just know I can do so much more damage than all of you put together. Know that. Going on to page 51. Try me. Page 72, July 20th, 2019, 11:34 p.m. From Janice to owner. No metadata, but from Janice. Sorry it's so late. I just read your text. He seemed fine when I saw him at your apartment this morning. He answered the door right away, but was quite bummed out that he overslept. But I was okay and told him, no problem, just get ready and come to work in about half an hour. Then I texted your phone and asked if he would rather work the afternoon shift and get some sleep, but he never answered, so I have no idea where he is or what he's doing. what happened last night. He had a black eye. He said it was new because I asked him and I told him to put makeup on it. He said he had that taken care of. Did you two get in it again? He acted like when I told him he had a black guy, at first he didn't know what I was talking about. I guess he kind of blacked out. You can call me back if you want. (11:30 p.m., 38 seconds. From owner to mom, Jorge. Janice just called me looking for Jorge and she's pissed. Congrats.
Yeah, it looks like they got married because she mentioned something about him wearing both his and her wedding ring around his neck. Why was he wearing her wedding ring around his neck? Because he was whipped, that's why.
Page 82, 8/21, August 21st, 2019. From Jorge to owner. I love you, my friend, my love, my queen, my everything.
Maybe they were just wearing rings as like a symbolic gesture.
Now that concludes everything I'm going to
Lindsay.
publish to the jury on this exhibit.
Do you think Shark Tank will give you 100K to make greeting cards
Yes.
out of these texts? You're crazy. So maybe they weren't married like on paper, like there was no marriage certificate, but she definitely tried to control him and treat him like as if they were married. Because what's with the wedding bands? Is it like a promise ring? Are you 7? You know, we're back to square one. Childish behavior. They weren't married, but she made him wear the wedding bands, huh? Son of a gun. What a twisted, twisted human being. I just can't. The level of control that she wanted and got over George. I like that the prosecutor was calling him Jorge because at the end of the day, I think that's his name. I don't know why everyone keeps calling him George. Jorge, at least in my mind, is pronounced Jorge. And I think he deserves to be called by his intended name. Just out of respect, you know. Maybe it's just me. I don't know. I feel like calling him George is not demeaning. I wouldn't go that far, but just not as intended. You know what I mean? But I could be wrong. I could be wrong. There's his family. He said he preferred George. Okay, you know what? Then we shall call him George. If that's what George wanted, then George it shall be, if that's the case. I will honor a deceased person's wishes. No reason not to. Yeah, she's not having a very good day, is she? Good. She didn't even comb her hair this morning. Look at the back of her head. She literally probably slept, woke up, put on a suit, and went into court. She's not even trying anymore. Either she thinks she's got it in the bag. Either she thinks she's got it in the bag, or she's given up all hope. Part of me tells me it's the former. She thinks there's no way she can lose. I have a very strong feeling. She thinks there's like no way she can lose. I'm telling you.
Members of the jury, thank you for your patience. I just have a short instruction to read to you. Members of the jury, the state showed you portions of what was entered into as State's Exhibit 21. It is not the entirety of State's Exhibit 21. The entirety of State's Exhibit 1 will go back to you into the deliberation room with a laptop for you to review all the exhibits and text messages and the total conversations over and above what was highlighted by the state. With that, State, do you have any other witnesses, evidence, or testimony to provide?
Your Honor, at this time, the state rests its rebuttal case.
Oh.
Anything further from the defense? You want to approach?
I just think we have some issues outside the presence of the jury.
Okay,
I have one thought though that requires a quick vote.
come on up.
Are they going to move for a directed verdict, a renewed motion for a directed verdict? I think the defense indicated yesterday that they don't have any rebuttal. They don't have any rebuttal. But does that mean we can just go into closings after lunch? What are the current standings on our little poll. Let's see. We have 360 plus votes, out of which 2 out of 3 of you, so about 240 votes, you think she's going to be found guilty of murder second degree. Only 1 out of 5, 1 out of 4 of you are saying manslaughter. Less than 10% of you, so about 36 votes are saying, so about 33 votes, I would say, are saying culpable negligence. And about 9 people voted not guilty out of 365. Sounds about right. Sounds about right.
All right, members of the jury, we're going to go ahead and excuse you for a couple minutes. I got some things I have to discuss with counsel outside of your presence. We'll bring you back in for additional instructions on where we think we're going to go after that. Similar instruction that I've given you over the last couple of days. Please do not conduct any independent research or investigation with regards to the persons, places, things, or charge involved in this case. And do not have any discussions amongst yourselves or anyone else about them. We'll bring you back in as promptly as possible. Thank you. Y'all can be seated. Thank you. The state has rested. Mr. Owens, do you have any intention on putting on a sir rebuttal in this case, sir? Yes, sir.
Judge, we did not intend to put on a sole rebuttal for the defense.
Okay, thank you. All right, Ms. Boone, I've got a couple of questions to go over with you, ma'am. You were previously sworn this morning. You've had the opportunity to review and participate in the trial. You've had the opportunity to review the rebuttal case as provided by the state. You've had the opportunity to review and listen to that evidence and witness any cross-examinations as it relates to the state's witnesses in their rebuttal case. Are you satisfied with your attorney's representation of you in this matter?
Definitely.
And are you still on board with the strategy that has been utilized in your defense?
Yes.
Now, your lawyers yesterday told the court that they may want to put on a sir rebuttal, which would be a limited rebuttal to the evidence presented by the state in their rebuttal, both yesterday and today. Your lawyers have indicated that they do not intend on doing that. Similar to other conversations we've had, ma'am, I don't want to know specifics. I just want to know if you and your lawyers have had these conversations. Have you had a conversation with your attorneys about putting on a sir rebuttal or a reply in response to the state's rebuttal?
Yes.
You had that conversation.
Yes.
Are you on board with the strategy employed by your lawyers that they are not seeking to put on a sir rebuttal in this case?
I am.
Okay. All right. Is there anything else that we need to address? State.
Judge, you remember you were going to say?
Yes. Thank you, sir. Ms. Boone, at the conclusion of the state's presentation of State's Exhibit 21, Mr. Owens had approached and advised the court of some objections, specifically with regard to the co-ownership or co-usage of the phone. The court is not permitted to comment on the evidence. And your lawyer was seeking an instruction from the court to advise our jury that both you and Mr. Torres had access to that cell phone. I am prohibited from commenting on the evidence. Now, that doesn't prevent your lawyer or the state from speaking about that in their closing arguments. Just as a matter of law, I am not able to advise the jury as to what that evidence is. The second request pertained to the state moving from place to place through those 108 pages, moving from timestamp to timestamp. The state chose to present that evidence in that manner, which is why I gave that instruction to the jury that not the entirety of Exhibit 21 was provided to them, as to what the state produced, and they'll have to have the opportunity to review that in its entirety when they go to deliberate. Do you have any questions about that so far?
So far, no.
Okay. The last portion, ma'am, pertained to the cadence or tone in which you and Mr. Torres communicated with each other. I have no knowledge as to how you and Mr. Torres communicated in text form as to what the tone was behind those words. Your lawyer advised me that there was an objection and you had some concerns as to the way Mr. J may have read those text messages to the jury. I found that the way that he read them was benign, in a flat tone, and did not exacerbate or excite any of the language that was in there. He read them in as a monotone way as possible in presenting to the jury, and I didn't notice any changes in his cadence or heightening or lowering in the volume or tense or tone utilized in presenting that information to the jury. Do you have any other questions for me, ma'am?
No.
Anything else we need to address, Mr. Owens?
No, sir.
Anything else we need to address, state?
No, sir.
Okay. How would we like to proceed with the charging conference? Do we want to bring back on our jury? It is 10:33 and advise them, this is when we think you want to come back because we're going to be addressing the law to provide to you. And that's something I need to do outside of your presence. How do we want to proceed at this time?
I think hopefully at 10:33 to about noon should do it for 3.6F. It is convoluted, but I think the parties have narrowed it down to really just a couple of things.
Okay.
So I would suggest saying something along the lines of, we have to finish up getting the jury instructions ready for you. That's something that we have to do now after the evidence is concluded, and we'll see at 1.
I say 1:30, Judge, in the abundance of caution, because, Mr. Henderson, I know this is gonna be an issue. And it's gonna take a little bit of time, and then we wanna go to lunch and give them a chance, because there's gonna be a 3-hour speech session. I don't know if you give them a break in between prosecutor's statement and my statement, or how you do
We
that.
may, depending on just the time of it.
And 2 is maximum 15
But
years, not
From
minimum.
1:30, that's gonna go to 2:30, 3:30, 4:30. So just before 5, I think that's plenty of time in case he goes a little bit longer or I go a little bit.
And I still have to read the jury instructions as well. So I mean, with 34 pages and I read quickly, as Madam Court Reporter will advise me.
Are they gonna have
yes.
you reading along with you?
Yes. So once we make all these changes, every member in the box will have a paper copy. You, Mr. Owens, and your team, along with Ms. Boone, will have a copy. The state will have a copy. Madam Court Reporter will have a copy, and I will. And I will read line by line all the way up into the 2.7 instruction. At that point in time, I will stop. I will advise our jury that we're going to begin with closings. State will go. You will go. State will have an opportunity for rebuttal. And then I'll finish with the verdict and final instructions. Discharge our alternates at that time. I'll go back and thank them and give them their jury certificate forms. And then we'll release the jury. I'll have a final colloquy with your client. And then we'll review all the evidence to send back with the exception of the baseball bat.
And perhaps in case they haven't inferred, let them know that they're getting the case tonight, so make plans to stay later.
Yes.
How late are you gonna keep them?
9 o'clock is the norm. I may, because it's the weekend and it's Friday, I may seek special dispensation from the chief to stay longer. I plan on communicating with the chief during the lunch hour as to that issue.
I think that would be great.
If she'll let me. I don't know if it's at her discretion. I know I have to seek approval after 7. I'm not worried about that. I know. And I would prefer them to work late into the evening if they're on board with doing that, rather than coming back Monday. Okay.
Wow.
All right.
We may have a
If you all
verdict
would be so
tonight.
kind to give me a moment so I can go back up to chambers,
Just like I predicted.
get with Ms. Barrios, and I'll give paper copies of everything from the revisions that we made this morning. Let's go ahead and bring back in our jury. And I agree with Mr. Owens. I'd rather us waiting on them than them waiting on us. So I think 1:30 is the way to fly. Let's go ahead and bring back in our jury.
Jury entering.
They're going to deliberate for at least 3 hours, minimum 3 hours. They have a lot of evidence to go through.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes, I do.
All right, thank you. Y'all can be seated. Members of the jury number 2 in the back, he's ready. He gets it. All right, can you raise those hands one more time for me? All right, record reflect, hands have been raised as compliance with regard to the court's instructions. Members of the jury, all the evidence and testimony sought to be provided by the state and the defense have been provided to us over the last week. At this point in time, the state and the defense and I need to discuss the law to be given to you in instructions. That's going to take a little bit of time. So we're going to go ahead and excuse you at this point in time for a longer lunch break than what you've had previously. And we're going to ask you to come back here at 1:30. At that point in time, the court will begin to instruct you on the law that you are to apply in this case. Then the parties will begin with their closing arguments. The state will go first, then the defense. Then the state will have the opportunity to rebut any of the defense's arguments. After hearing the closing arguments, the court will provide you final instructions before releasing you to deliberate in this matter. We may work past 9 o'clock tonight. We may go late into the evening. So if there are any plans or things that you need to reach out to, as we discussed last week during jury selection, that we could work till late as 9, and we may work later than that this evening. If there's anyone that has any concerns as to working that late, please raise your hands at this time. Court sees no hands.
Wow.
I would also ask of you, if you could, please reach out to any family members or friends to, one, advise them that you're on the jury and will be deliberating this evening. And if there's any accommodations or issues with minor children or family that need to be taken care of, I would ask you that you take care of that during our lunch break.
And the emergency phone number, since they don't have phones.
Yes, we will provide you. The court deputy will provide you the emergency phone number when we get back from lunch, so that you can provide that during a break that we'll have this afternoon to any friends or family or loved ones if they need to get in contact with you. I will give you a similar instruction that I've given you over the last couple of days. I know you're probably tired of it, but I got to give it to you one more time. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not you must not use phones, computers, or electronic devices to communicate. Do not send or accept any messages related to this case or your jury's service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I thank you for your attentiveness, service, and sacrifice, and we'll see you at 1:30. Juror number 2 in the back. Yes, sir.
Question. So
Answer.
the parking, we're going to be here for some time. Can we leave and come back and get re-stamped with a new thing?
We will have you that answer when we come back.
Okay.
Madam Clerk's going to figure that out for you.
Okay.
All right, thank you very much.
He's got a lot more clerks today, the judge. He's got like the 2 guys that were usually there and 2 females now as well. He's got 4 people in checking this stuff out, checking this case out. That's crazy.
Okay. Could you do that, Officer Jones? So I've been advised by, you know what, rather than double speak, could you just tell me what it was? Say it for the record, what it was.
Judges approve that they are to go off campus or out of the courthouse
garage, they can come back and get new stamps, cards, and everything.
So they can leave this point during lunchtime. Okay.
And I'll approve that.
Yeah, for
So,
law students.
State, anything else we got to discuss other than the jury instructions?
What did I say? That's
Defense.
clerks. Same thing.
Okay, court's going to run upstairs, put the finishing touches on what we agreed to this morning. I'll bring back paper copies for everyone, and then we can continue the charging conference. At that time, court's going to be in a short recess. We'll be back as promptly as possible. Thank you.
Thank you.
Okay. Oh, wow. This case is moving so fast. I have never in my career seen a murder trial. Lally, take notes. Adam frickin' Lally, yo. You turned a potentially 1 to 2 week trial into a 7-week trial, you mofo. Actually, more than that. Wasn't it 8? How long was the Karen Reed trial? It started April 15th, right, with jury selection. April 16th. 15th was a Monday. It started on a Tuesday. And we had a verdict in wasn't it like July 1st? Or not the verdict, but the discharge of the jury. When did the Karen Reed case end? July 1st. Oh my God. Yeah, that's right. So what is that? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 weeks. It was an 11-week trial. I mean, some weeks were like a day, I know, but still 11 weeks. It was like 3 months almost. Whereas this case, 1 week. It started last Friday. I mean, I think they started jury selection on Monday. When did Sarah Boone jury selection begin? I want to say it was on the 14th. Yeah. So jury selection started 2 weeks. This is a 2-week trial. This is a murder trial. I mean, it's obviously different because here she's guilty of sin. Oy. 2 weeks. 1 week of testimony and evidence presenting. 1 week to pick the jury, 1 week to present the evidence. Bing, bang, boom. Send it to the jury. So in about 3 hours, the jury is going to listen to the jury instructions and they're going to start closing arguments. There's no reason not to, right? What are we waiting for? I think the jury's going to have a verdict tonight, folks. I really do. They're not going to want to go into the weekend. They want to go home. They'll leave at like 11 p.m. if they have to. They'll deliberate for like 7 hours or something. Maybe 6. I think 6, 7 hours is a good number for them to deliberate. There's still some evidence that they have to go over, they have to discuss. There's not 12 of them, there's only 6, so it's going to be faster. So it's not going to take like 2-3 days. Did they ever play the body camera footage of her the day of? Did they play it in the beginning? Because I missed it. Oh, thanks, Vicky. I think we're going to have a verdict tonight. So let's say they resume at 1:30. The jury's now on notice that they'll basically stay there as long as it takes to get a verdict. So they might actually accelerate the process. The judge is artificially accelerating the process a little bit. But you know what? I don't blame him. And I don't know. As a defense attorney, it kind of rubs me the wrong way a little bit. But the case is so bad. And there are like no issues on appeal. The judge is really making sure of that. so that Sarah can't go back and say, wait, ineffective assistance of counsel. It's like, listen, woman, I asked you 25 times during the trial, are you satisfied with your attorneys? Yes, 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 yes. So remember, these are the potential punishments for Sarah, or potential verdicts, I'm sorry, that they could render. The third one, I'm not 100% sure about because I don't know Florida law. I just did like a cursory search. But the first two and the last one, of course, I'm very certain about. Murder in the second degree, minimum sentence 16 years and 3 months to maximum of life imprisonment. Florida's weird. They do like years and months. But anyway, manslaughter second, 9 years and 4 months up to 15 years. So that's basically what the government was offering. It was offering a max on the man two. Life in prison is on the table. Yes. Life in prison is on the table if the jury convicts on murder two. If the jury, so the jury can acquit completely, say not guilty, reason of battered wife syndrome, battered spouse syndrome, whatever. They can determine she reacted in a way that is commensurate with someone who has been abused or whatever. I don't think so. I don't think so. The text messages and the videos that they showed yesterday and today are too damning. They show her as a psychotic control freak who has been ordering this poor man around and taunting him, and they saw the suitcase the day of the murder, a video which again I refuse to see, and so I think that's going to play a huge role in that as well. Then so not guilty is probably off the table. Like I said, felony culpable negligence, I think it's up to 5 years when there's a death involved. Again, the judge is going to be deciding. They're not deciding these. They're only deciding these: murder, manslaughter, or felony culpable negligence. So just this side of the colon. This side will be decided by the judge. So they get to decide, is there enough culpability for... So I think felony culpable negligence, even though it is an element of murder, manslaughter in the second degree, I don't think felony culpable negligence is enough. They have the government has presented more than that. So 4 and 3 are probably off the table. The question is 1 or 2. Is the jury going to convict on murder second degree, or are they going to convict on manslaughter second degree? And theoretically, it's possible that they convict on manslaughter second degree, and then the judge gives her the max, and that's the offer that she had on the table. So she just spent 2 weeks with her lawyers getting the exact same offer the prosecution made. The prosecution, I think, made a very reasonable offer. 15 years is a very reasonable offer. And she might get that from the court. There's a very high possibility that the case is going to get resolved in the exact same way that the prosecution offered. But if they vote murder, if they're like, no, woman, you... Again, let's look up murder 2, because this language is crucial. In Florida, second-degree murder is the unlawful killing of another without premeditation, but with a depraved mind and an indifference to human life. So let's look at that language. Depraved mind and indifference to human life. How is that defined in Florida? In Florida law, depraved mind and an indifference to human life refers to a mental state when someone commits an act that is so recklessly dangerous and shows such a disregard for the potential to cause death or serious injury that it demonstrates a complete lack of concern for human life, essentially indicating an evil or wicked intent, even if there wasn't a specific intent to kill a particular person. So you don't have to intend to kill, but you're just so recklessly, with such a lack of concern for human life. This is typically used to define second-degree murder under certain circumstances. The act must be imminently dangerous. The action taken must be considered by a reasonable person to have a high likelihood of causing death or serious injury. I mean, in the video, I understand he was saying, I can't breathe. And she just, oh, yeah, Sarah, yeah, that's my name. Don't wear it out. You know, I've heard what is in that. So there's no premeditation required. Like, I didn't plan this. When he gets in the suitcase, this is what I'm going to do. Unlike first-degree murder, a depraved mind murder does not require premeditation or a specific intent to kill. So there's no intention required. You guys keep saying, like, well, she didn't intend to. Well, that's murder too, also. Murder too does not require premeditation or intent. Examples. Firing a gun into a crowd. These are very famous examples. Firing a gun into a crowd or into a building, for instance. Driving a car at a high speed towards pedestrians, kind of like what's his name, Daryl Brooks did. Throwing explosives into a populated area. That sort of thing. This is a depraved mind and indifference to human life, and possibly leaving someone in a suitcase. Leaving someone in a suitcase overnight after they said that they cannot breathe. Is that depraved mind and indifference to human life? Maybe. The jury will get to decide. I don't know. The more I read the law now, and we're going to hear this from the judge in a few minutes. Well, I say a few minutes, couple hours, really. We'll hear this from the judge at like 1:30 when he starts reading it to the jury. If this is the language that he's going to use, it is very, very, very possible that the jury will convict on murder second degree. Because look at manslaughter 2. Second degree felony involves unlawful killing of a person without malice aforethought. Remember malice from the Johnny Depp trial? And intentional killing without premeditation. And like a heat of passion, that's a voluntary manslaughter. That's probably not it. Involuntary manslaughter, the unintentional killing resulting from reckless or negligent behavior, such as accidentally firing a gun, for instance. So that's what the jury really has to decide. This is the language that they have to decide. Was Sarah's conduct reckless or negligent? Or did she act with an evil or wicked intent? If they determine that she just acted with recklessness or was negligent, that's manslaughter 2. If they decide that she acted with evil or wicked intent and demonstrated a complete lack of concern for human life, that's going to be murder 2. She doesn't have to intend to kill. Remember, no intent is required in either of those. Wicked, evil intent versus pure recklessness or negligence. Okay? I want to do another poll because this is very interesting. Now that we're getting into the language. We're going to get our own little jury here. Where is it? Here we go. All right. Let's get a poll up. That was me. Sorry. Start a poll. All right, polls up. Wait, where'd it go? Oh, did I already post it? Huh. Yeah, I did. Okay. It's up on X/Twitter, and it's up on my poll. See, because when you ask people, do you think Sarah acted, or sorry, when you ask people like, do you think Sarah is going to get convicted of murder or manslaughter? They don't know the language being used. You know, maybe some of them didn't look it up. They're just like, oh yeah, it looks like murder. Oh yeah, it looks like manslaughter. But when you use a specific language like recklessness, negligence, that's the language of manslaughter. When you use the language of wickedness, evilness, depraved behavior, disregard to human life, then people are going to be maybe a little bit more on point with voting more accurately. You know what I mean? Like, the more I think about it, I was actually, after yesterday, I was on board with manslaughter too. I couldn't believe it. I was like, wow, she may get off in manslaughter. After today, and don't forget, I also caught up with an hour of footage, of cell phone footage this morning. So I had that going for me, plus all the text messages. I am now leaning towards murder too again. Especially that language. That language is huge. Huge. Recklessness. I cannot say she just she did not act negligent. There's no way you can just call this negligence. Recklessness at best, but it's included in the involuntary manslaughter 2 charge. Recklessness at best, but I think it goes beyond. She had a depraved mind and an indifference to human life by leaving him in the suitcase overnight, going to sleep. And notice, voluntary intoxication is not a defense. It looks like murder 2 continues to win the day. Evil and wicked. We do have a minority that is saying recklessness and negligence. And we do have an extreme minority saying it was a complete freak accident. And an even more extreme minority saying she's not guilty of anything. So that's where we're at. That's where we're at. He played a part in his own demise. It's a very interesting argument. It's a very interesting argument, but the problem is the video. The video of her taunting George while he's in the suitcase saying, I can't breathe, and she taunts him, you know, yes, my name is Sarah, don't wear it out, that sort of behavior. She was complicit. You can't, like I said, it would be a completely different scenario if they're playing hide and seek. George got into the suitcase and she had no idea and she thought he left. And she went upstairs and went to go to sleep. And George is by himself and she has no idea where he is. She thinks she left the house. She thinks he left the house, wakes up and he's in the suitcase dead. That would be a slam dunk victory for her. Slam dunk. He's 100% complicit. He accidentally offed himself. That would be a complete accident. So it's an interesting theory, but I think it fails on its face. I think it completely fails on its face. So him getting into that suitcase initially, you can't have a comparative negligence in a murder trial. Now, in a civil case, maybe. In a civil case, maybe you could argue like he was partly to blame for, getting into the suitcase. And instead of like, let's say the verdict would be like $1 million and you discount it by 30%, and she only owes 70% because he got himself into that situation. So she had to make the choice. Do I unzip him and let him out? Or do I keep him in there? And she kept him in there. And she actually took a baseball bat after he tried to like slide his hand out, and she jammed that hand back into the suitcase and zipped it up. That shows consciousness, an overt act. We have the video of that. Not the baseball bat part, but the video of him being in the suitcase saying, "I can't breathe." And she admitted herself that she used the bat to get his hand back in. But for the videos, it would be a different story. But the videos really seal her fate, in my opinion. She ripped up the birth certificate, man. Who does that? She ripped up the birth certificate. Like, what kind of person does that? And then she sends a photo of it to George's mom. Like, quoting Taylor Swift. Look what you made me do, or whatever the hell. That is so freaking low. She liked taunting George. She liked taunting George's family. She is a very, very sick and twisted individual. Very, very sick and twisted individual. And that comment about Hispanics, it doesn't matter what she intended. It sounds racist. It sounds like very nasty. Go be Hispanic or whatever she said. That's what you Hispanics do. I mean, come on, dude. That is such a lowbrow comment. Like, you're dating him, allegedly. If you don't like him and you don't like Hispanics and you don't love him, then, well, her argument is he just wouldn't leave. Battered wife, battered spouse. Hey, Jacqueline Weaver. No, the jury doesn't have it yet. They are about to get back to discussing jury instructions, and then at 1:30 the jury is going to come back to deliberate. Or sorry, listen to the closing argument. I'm sorry, listen to closing arguments at 1:30. And so they're probably going to start deliberating around, I don't know, 3 p.m. We're going to have a verdict tonight, folks. We're going to have a verdict at like 9 p.m., which kind of sucks that I won't be able to stream it. Tonight I have plans, so I won't be live. Especially if we get a verdict at like 9 p.m., I'm going to be gone. But I'll probably do a video tomorrow or something. There's no sound yet.
We're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
Nick Petro on behalf of the state. William J. for the state.
Defense?
Tony Henderson for Sarah Boone. Kevin Mack on behalf of Sarah Boone, Your Honor.
Okay. Where might Mr. Owens be?
Judge, Mr. Owens is doing some preparation.
Okay. If the state and the defense can approach, I have paper copies of the revised jury instruction. You'll see on the bottom of each page is a file and path name. That's just for my own edification of where I've stored them. So then we make additional changes. The revisions that we discussed earlier today have already been made. There's still a couple cleanups that I need to do just to get rid of the formatting items, but all the revisions that we spoke about this morning have been included. With that, I think that takes us to page 9 of 28 in the 3.6F instruction. I also have the defendant's revised portions as to 3.6. Just for the court's clarification, is what is in page 9 of 28 of what was provided to the parties, is that the same as the separate defense 3.6F instruction?
Yes, Your Honor, it was only provided for more convenience for you to copy and paste them.
Got it. Okay, so should we be relying on the 3.6F instruction you, Ms. Henderson, sent last night?
Yes, sir.
Okay, all right. State, do you have that?
I have a digital copy of mine.
Okay, all right. Tell me when you have it pulled up in front of you, sir, and then we'll.
It's pulled up and I sent everybody the state's digital copy as well.
Okay, very good. All right. Let me pull up the digital copy that I have. Give me a moment.
Yes, sir.
Okay. All right, the court has the 3.6F instruction as provided by the defense. As to the first paragraph, it is a defense to the crime, bracket S bracket, of second-degree murder and culpable negligence if the actions of Sarah Boone constituted the justifiable use of or threatened use of deadly force. What say the state as to this instruction? And should not manslaughter be included?
It should be second-degree murder, comma, manslaughter, and culpable negligence, even though culpable negligence doesn't involve an intentional act. But I'm not going to fight with that.
Okay. Any objection to that addition?
No, Your Honor.
Okay.
Judge,
Yes, sir.
can I interrupt for just a minute? Because there's a special instruction that the state is requesting on causation.
Yes.
And that goes, it's going to come before the self-defense.
When it was used in the previous case that I cited, that I used it in 12 years ago, it's part of the instructions in second degree murder. Yes, is where I would be requesting it.
And this is just so that we're all on the same page. Forgive me. This is the state's request for special jury instruction on causation.
Yes, sir. I suggest we table that for now, just get to self-defense.
Okay. All right. So we'll revisit the state's request at that point in time. So is the second or the first full paragraph is read, is that acceptable to the defense?
Yes, Your Honor.
Okay. Moving now to the deadly force definition. That seems to track the language of the proposed jury instruction completely. Any revision to that state? You've got no quarrel with it.
No, Your Honor.
Moving to the next paragraph, I also believe that that's from the Form 3.6 instruction. State, any issue with the third full paragraph?
So in my request, I struck through or threatening to use each time because the evidence doesn't support that. What the evidence supports is she did actually use force. It wasn't a threat of force. So I think it's unnecessary and confusing and not supported by the evidence to have that clause in each of the paragraphs where it's mentioned.
Response, defense.
Judge, I have no problem with that. I was just, when I put it in, I just was going on some statements that the state had made in different arguments. So, especially when I'm talking about aggravated assault.
Okay. So just so that I'm clear, you've got no objection to the removal of that language. So the third paragraph would now read, Sarah Boone does not have the burden of proving that she was justified in justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. Is that correct, state?
Yes.
Is that correct, defense?
Yes.
All right, very good. Yes, sir.
To make it quicker.
And Mr. Henderson, you don't need to stand up every time, sir. I appreciate it.
I'm sorry, but it's old.
I get it.
But it's out of habit. Judge, every time that comes up,
You lose it?
yes.
Understood. So then just let's go back to the title then. Can we revise the title to 3.6F, justifiable use of deadly force, and remove that bracketed or threatened use language?
It should just be used.
Okay, very good. All right. The next sentence, the law on the justifiable use of deadly force is as follows. Is that acceptable? State.
Just the strike through
Uh,
or threatening.
As I read it, yes. Is that acceptable defense?
Yes, Your Honor.
Moving now, Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent A, imminent death or great bodily harm to herself. Is that acceptable to the state?
It's acceptable. Just confirm that they don't want me.
Yes, confirmed. Only what would be read would be A.
That's correct.
Okay, all right. Is that acceptable, state, with that understanding?
Yes, sir.
Okay, moving now to the next portion. Sarah Boone had no duty to retreat before using deadly force. I mean, my review of the case law, and I don't recall which one it is that if you're on your own home, you don't have to retreat.
My understanding of the facts was that she used force first by zipping him up in the suitcase and doing so that, one, she could make him feel like he had made her feel in the past for choking and cheating on her, and two, to give her a platform to be able to speak to him as a captive audience, and he would have to listen. Because she took the actions of an initial aggressor, it is our position that there is a duty to retreat caused by the initial aggression, as that is addressed lower in the jury instructions.
Response, defense.
Judge, I have a different view of the evidence. I think what the evidence has said about the initial in the suitcase is that Mr. Torres was getting into the suitcase and positioning himself into the suitcase when Miss Boone came down. There was laughter between the two of them. The suitcase was zipped, and it was a consensual deal. It was a consensual thing. She didn't use any threat or use of force at that time to zip him in the suitcase. Furthermore, during the demonstration and when they were demonstrating the suitcase and the zipping ability, I know time has passed, but I hadn't seen anything different to keep someone in there who didn't want to be in there. If someone didn't want to be in there, it would be almost literally impossible to zip that suitcase because how much force it took to zip that suitcase. So the evidence doesn't support it.
Doesn't support a duty to retreat?
Correct, because what they're saying, going back even before we had stand your ground, just going back to the castle doctrine, there was never a duty to retreat from your home.
So then if I understand your argument, you are not seeking to have this included then?
I am seeking.
Because if you're saying she had no duty to retreat,
That's correct.
this talks about hang on, let me just reread it. Okay, so I think I follow your argument. Okay.
What I'm saying is that it should be no duty to retreat, that Sarah Boone had no duty to retreat. That's what we're requesting. I believe the state's objecting to that and saying that it is a dispute. So they want the next paragraph as to the court. But there is nothing that showed at that time, because the state's arguing that she forcefully put him in the suitcase.
Response.
That's a strong argument. That is not the state's argument. We know what the evidence in this case is. The evidence that she provided was he got into that suitcase by himself and they were playing hide and seek, and he was inside but not completely hidden. The lid was flapping over him. She came over and zipped it shut to whether it's 100% or near 100% shut. And it was all in fun and jest at first, but he did indicate, and we saw it on the video, image IMG_1062. Sarah, I can't breathe. Sarah, I can't breathe. He was being held against his will in that suitcase. That there is no requirement that she initially forced him into it or not. It's no different than two people wrestling and play fighting, and one person has another person in a headlock, and then there comes a point in time where I'm tapping out. Jorge Torres was tapping out. That's on video, and it's in her testimony. It's uncontroverted. There is sufficient evidence for there to be a dispute as to whether or not she was the initial aggressor, and whether that generates a duty to retreat. Quite frankly, it's undisputed evidence because it's uniquely only her testimony coupled with the video. She restrained him in that suitcase on purpose and intentionally. And if you look at the elements of aggravated assault in our proposed jury instruction, that is exactly what was going on. She intended for him to feel fearful of an inability to breathe, to make it feel like he had made her feel when he had choked her. An aggravated assault is defined as follows: Sarah Boone intentionally and unlawfully threatened, either by word or act, to do violence to George Torres. She would not let him out. She would not release the headlock when he indicated he could not breathe. At the time, Sarah Boone appeared to have the ability to carry out the threat. Well, the video evidence is res ipsa loquitur. He could not get out on his own. He could not get out on his own at 11:12 in the first movie. He could not get out on his own at 11:23 in the second movie. And quite frankly, he couldn't get out at 11:03 during the still photo as well. Element 3, the act of Sarah Boone created in the mind of George Torres a well-founded fear that violence was about to take place. Absolutely. Sarah, I can't breathe. Babe, I can't fucking breathe. Sarah, shh, go fuck yourself. The assault was made with a deadly weapon, element 4. An object not designed to inflict bodily harm may nevertheless be a deadly weapon if it is used or threatened to be used in a manner likely to cause death or great bodily harm. Well, ladies and gentlemen, it did cause death. So that's not in dispute. So it's our position that she was the initial aggressor based on her testimony that we received in court, and that is going to put into play a duty to retreat, and that the parties can argue about that.
Anything further, Mr. Henderson?
Yes, Judge. I want to clarify this because what the initial thing in getting into the suitcase, the act is zipping the suitcase up. That act of zipping the suitcase up was not done forcefully. The testimony was he agreed. He was in the suitcase. He was the one who got into the suitcase to begin with. He agreed. The suitcase was zipped up, and there was no argument at that time. All right. And just by the demonstration that they gave, you could see somebody to get in that suitcase or not get out of it at that time wanted to be in that suitcase. And there's nothing to dispute what she says, that he agreed, she zipped the suitcase, and they both laughed and thought it was funny. Now, the next thing that the state goes to is an omission. It is not an act. It is an omission at that point in time where she's saying, when they say, oh, he can't breathe, well, she doesn't go, let him out. So they're saying, so they're trying to make that an act when it is not, when she just did not let him out. It's different. And what we're talking about is just the duty to retreat at this time. We're not even talking about the other parts as the thing, but as to the duty to retreat, she's in her home. And at that point in time, when that act took place, she had no duty to retreat.
Here's what the form instruction says. If it is undisputed by the parties that the defendant had no duty to retreat, give the following sentence. Defendant had no duty to retreat before using or threatening to use deadly force. Instruction goes on to read, if the parties dispute whether the defendant had a duty to retreat, give the following paragraph. It sounds like both of y'all, are disputing whether or not there's a duty to retreat.
Yeah.
So I think I have to, based on what the Florida Supreme Court's instruction to me is to give that second paragraph. State, anything further?
No, thank you.
Defense, anything further?
Just note the objection, but I understand the court's ruling.
Okay, all right. So the language in the red line from the defense as to Sarah Boone had no duty to retreat before using deadly force will be removed. And I will add in the state's proposed language, which tracks the form instruction. Is there any objection? Do you want me to read that to you, Mr. Henderson?
No, I'll read it real quick, Judge.
Okay. And I just want to make sure we're all on the same page. That's the state's proposed revisions to the 3.6F on the top of page 2 of 7.
Yes. I'd ask that the court would read it.
Sure. Okay. If Sarah Boone was not committing any crime other than the alleged second-degree murder or manslaughter okay, I will add that. Thank you. For which, so it'll read, if Sarah Boone was not committing any crime other than the alleged second-degree murder or manslaughter or culpable negligence for which the defendant is claiming self-defense or defense of others, and if she was in a place where she had a right to be, then the defendant had no duty to retreat before using deadly force. On the other hand, 1, if at the time Sarah Boone used deadly force, she was committing an aggravated assault, or if at the time Sarah Boone used deadly force, she was not in a place where she had a right to be, then the defendant had a duty to retreat. The duty to retreat means the defendant had the legal obligation to use every reasonable means to avoid any danger before using deadly force. The law does not require the defendant to retreat if she was placed in imminent danger of death or great bodily harm or imminent danger of the commission of parentheses applicable forcible felony end parentheses against herself, and it would have increased her own danger to retreat, or if retreat would have been futile. But if the defendant had a duty to retreat, and if she could have safely retreated but did not do so, then her use of deadly force was not justifiable. I do have a question as to the applicable forcible felony
I
portion
believe
of
they
that.
were waiving B. That's for her, for the A and B that we already previously discussed, not for the.
That is correct. So then that sentence would be revised to, the law does not require the defendant to retreat if she was placed in imminent danger of death or great bodily harm, and it would have increased her own danger to retreat. What say you, Mr. Henderson?
Judge, I enter objection as to the instruction, as the state has included to get this instruction, an aggravated assault, which is not charged in the information.
State response.
Judge, I'm happy to hop into that one as well.
Okay.
I understand what Martinez versus State says, and I'm sure we've all read the opinion. It's in my motions, and I understand what it holds. What it says all throughout the opinion is there needs to be an independent forcible felony. And then at the very, very end of the opinion, then it says there needs to be an independent felony charged. Why I'm asking for a special jury instruction, and I've made that request in writing, is because under the standard jury instruction that we are going through right now, it says, according to Martinez versus State, that the independent forcible felony needs to be charged. The whole purpose of this is you can't engage into a circular logic argument that defeats Ms. Boone's right to self-defense. So it would be preposterous to include in this jury instruction, Ms. Boone did not have a right to use justifiable use of deadly force by committing second-degree murder against the victim when that's the charged offense. But she, of course, would have the right to use deadly force to defend herself against the victim, and that would be correct. But what we have in this case, and what the state has alerted the court and the defendant to well before trial, was the evidence shows that she committed a separate aggravated assault. She, at the time that she had already zipped him shut in there, and again,
The baseball
because
bat.
she releases that quote unquote chokehold by sitting on the couch, she is exerting that force through distance because she's the one that zipped him shut.
Oh,
So she, in using that force, is the one who did that on purpose to make him feel like he was choking and make him feel like he had made her feel like when she was getting cheated on, and to intentionally confine him in a place so that she could speak to him about her thoughts. As I already outlined, it's the state's position, and the evidence does support that this is an aggravated assault. She intentionally put him in fear of death. She relished it. She relished it for that 2-minute video. That is prior to when she says, well, now he's sticking his fingers out and I get scared by that action. And by that action, it's Jorge Torres just trying to exert the will to live and to survive and be on this earth. That now that action, if his attempt to escape out of the suitcase that she has left him zipped up in is this independent threat of great bodily harm and death to her. She testifies if he gets out, it's her belief that he will beat her up, kill her, disfigure her, so on and so forth. In her testimony at trial, I believe she said he said that I will end you. So what we have here is they, by their own admissions, through the testimony that she provided, that there is a separate and distinct independent forcible felony from what ends up being the second-degree murder. What ends up now being the second-degree murder is at this point in time when she says, well, he's trying to get out. I'm afraid if he gets out, I'm going to get disfigured or killed. And so that is why Ms. Boone makes the decision, and I'm not even going down the aggravated battery path. But she batters him with a bat on the hands and batters him, pokes him while he's in the suitcase, and basically beats him into submission so that he stops trying to escape. That's what the testimony was. And then she makes the decision to now leave him and go upstairs and go to sleep without having relieved him from the force that she exerted earlier committing aggravated assault. So like the example I gave you earlier, this is absolutely no different than me pointing a gun at you, Judge, and putting you in fear of your life that I'm going to shoot.
Why did they never charge her with false imprisonment?
Or give you great bodily harm. And you,
It just
in
hit me.
turn, after having been placed in fear by me pointing a gun at you,
I guess they want the whole kit and
defend
caboodle.
yourself and exert your right to live on this earth by pulling your own firearm. And now, do I, as the initial aggressor, the initial person who committed the forcible felony of aggravated assault on you, under the law, I don't have the right now to defend myself against you. I need to retreat. I need to make it clear, sorry, man, my bad, drop my gun and walk away. That is what is the law. 776041 is a very short and very, very simple statute. And it has not changed since 2014. This has been the law. This was the law at the time of this offense in 2020. 776041 provides the justification described in the preceding sections of this chapter is not available to a person who, one, is attempting to commit, committing, or escaping the commission of a forcible felony. So taking away the firearm example, it's a chokehold. His cause of death, according to the medical examiner, was asphyxiation by position and environmental suffocation, caused by her not releasing a chokehold on him when he indicated, babe, I can't breathe, Sarah, help. That is an independent forcible felony, separate and distinct now from what she says is the victim, like you, pulling a gun to defend yourself from me pulling a gun on you. Now, the threatened use of force that the victim is exerting is sticking his hands out and saying, I'm going to end you. That is the distinct break between the aggravated assault and now her continuing to use this unlawful force, which she's not entitled to do because she started it. She was the initial aggressor in committing this aggravated assault. And she ends up just leaving him to die and never releasing the chokehold.
And the unlawful threat is what's on the video in your realm.
Yes.
Okay.
And any facts that support that should cause this jury instruction to be given. The absolute only hang up about whether or not this jury instruction should be given is because Martinez slightly overstates what is necessary to prevent this circular logic, which is not going to occur in this case. There is not going to be any arguments by the state that she does not have the right to defend herself if she is in imminent fear or death of great bodily harm by the victim. She testified that him sticking his hands out of the suitcase and saying, I'm going to end you, put her in fear of imminent death and great bodily harm. And in turn, what she did was she decided to not let him out. And he ended up dying. And that is second-degree murder. That is separate than what preceded that. What preceded that was her not letting him out when you can see him pushing up on the suitcase in the video, begging to get let out, and she doesn't because she is doing this out of anger, hatred, ill will, and spite to teach him a lesson and put him in fear of death or great bodily harm. That's an aggravated assault. I would absolutely charge her with aggravated assault and aggravated battery, separate independent forcible felonies, if I could. But I did not learn this information until after the statute of limitations had passed. That is through no fault of the states. So we absolutely would, if we could, and we are not going to make the argument and defeat her defense of second-degree murder by saying, well, you can't defend yourself with second. I understand what they're getting at in Martinez. That's not this case, though. It's broken down into those parts.
Can I have the citation for Martinez? Because unless I missed it in your motions, I didn't see Martinez cited in the motions.
I'm sorry.
And forgive me if I
No, it's been in previous motions.
Because you cited a Cologne with regard to the Miranda issue.
No, I'm referring to, there's a pleading entitled State's Request for Forcible Felony Instruction and Request for Initial Aggressor Instruction, which we've kind of hopped into now since aggravated assault is being mentioned in this paragraph. In paragraph,
Oh, there it is. I apologize.
yeah, paragraphs
Thank you.
12 through 31 are the legal analysis, and Martinez is cited in there at paragraph 19 at 981 Southern 2nd 449 Florida 2008. And more importantly, what Martinez doesn't say is that there's like some requirement that the verdicts would be interlocking. Like there's no requirement that second-degree murder be count 1 and aggravated assault be count 2, and then if they return a not guilty verdict on aggravated assault, then there has to be a not guilty verdict on the second-degree murder. That's not the case, because there's so many different prongs to the self-defense instructions. So it's not required to be charged for some reason of an interlocking verdict. And the whole spirit of that opinion is that it is to make sure that we do not defeat her self-defense argument that she's entitled to make about why she committed second-degree murder. All we're saying is you're not entitled to defend yourself in that manner if you committed an aggravated assault to start this. And that's what the facts show. It's a little complicated, and there's another special jury instruction related to this force by distance. It's like tying somebody to some train tracks and walking away. I mean, are you still choking the person? No, but are they restrained in a manner that if a train comes, they will die? Yes. So the special circumstances of this case and the facts are going to warrant, in the state's estimation, the forcible felony paragraph, and then that language being placed into this initial paragraph that we're talking about.
Just reading Martinez. Give me a moment.
Yes, sir. And then just for the record, the 3 prongs for a special jury instruction, which I cited in a couple of my other pleadings. A special jury instruction is warranted when A, the special instruction is supported by the evidence, which is the case. It's in fact undisputed since there was only one person there. B, the standard instruction did not adequately cover the legal theory it is meant to. That is also true. And C, the special instruction was a correct statement of the law and not misleading or confusing. That is also the case. Stevens, Stephen's versus State, 787 Southern 2nd, 747, and I mistakenly put 657, I imagine.
I think it's 755 is the pinpoint.
Yep, 2001.
Yeah, I reviewed that already. Thank you. Response.
Response is clear, Judge. They're trying to make exceptions for the law. That doesn't work here. Simply this, what the requirement is under Martinez to get the aggressor is this. It's only applicable and only in cases where the defendant was charged with either an independent forcible felony, that's Martinez, or B, felony murder. That's a different case. And Martinez, they have not charged an independent forcible felony. So it doesn't apply. It tells us right there, that's the standard jury instruction. For him to come back here and say, well, really, Judge, they overstated Martinez. Martinez is still good law. It has not been changed. That's the rule. That's the requirement.
But this is relying, Martinez's opinion states, indeed, consistent with this case law in 2006, we approved an amendment to the self-defense jury instruction to specifically provide that the forcible felony instruction should be given, quote, only if the defendant is charged with more than one forcible felony. That doesn't seem to be what the new instruction says, unless I'm missing something.
I'm sorry, can you repeat that?
Sure. The sentence says, indeed, consistent with this case law, in 2006, we approved an amendment to the self-defense jury instruction to specifically provide that the forcible felony instruction should be given, quote, only if the defendant is charged with more than one forcible felony. And unless I'm missing something, a 3.6F instruction doesn't say that now. The form instruction.
Judge, when it comes to the aggressor in the standard jury instructions, when it comes to aggressor, and they're talking about under 776.041 sub 1, it's to only be given if and only in cases where the defendant is charged with either an independent forcible felony. You cannot give this instruction unless there's an independent forcible felony that Ms. Boone has been charged with. And there just isn't one.
But where does it say that in the form instruction?
Judge?
Yes.
It's page 14 of 28. Aggressor, 776.041, prime 1, Florida statute, give if applicable and only in cases where the defendant is charged with either A, an independent forcible felony, Martinez versus State, 981-449, Florida 2008.
Hang on.
Or the felony. And we're acknowledging that. But when you look at the case and what it is stating is the purpose of that is there has to be in the evidence an independent forcible felony. And that is what occurred in this case. She committed an aggravated assault. After that, the defendant is saying the victim placed her in fear of imminent harm or death by trying to escape her aggravated assault, by sticking his fingers out, and by saying, as he's trying to escape, I'm going to end you.
But isn't that in the giving the aggressor definition? I mean, is that, but unless I missed something, that's not what we're talking about right now.
I agree, but I think it cohabitates together.
Okay.
And it's our position, we absolutely would charge her. And it's a legal technicality in part of this standard instruction that we can't because of the statute of limitations. We all know, all of us here together as attorneys know that those facts, if believed by the jury, support that she violated chapter 776.041, 1. She should not be able to get away with murder because of a statute of limitations technicality that was through no fault of the state's own. The purpose and spirit of Martinez is to make sure that we're not up there arguing, ladies and gentlemen of the jury, she had no right to defend herself from an imminent threat of harm by killing somebody. That's not what we're going to say. We understand that. What we are going to say is, ladies and gentlemen of the jury, she had no right to leave him in that suitcase out of fear and great bodily harm or imminent death because she committed an aggravated assault to put him in that predicament. That's the evidence in the case. That's the arguments that's going to be made. That's why we're making a special instruction request based on the unique facts and circumstances of this particular case.
Give me a second.
Yes, sir.
Proposed, the language in the instruction in pertinent part says he or she was committing an act, insert the defendant's criminal activity that the defendant act, but the criminal activity cannot be the charged crimes for which the defendant is claiming self-defense or the defense of others. The charged crime, second-degree murder. So I'm struggling with understanding as the other crime is, because I'm not hearing any argument as to the applicability of aggravated assault.
Judge. Because, and I didn't make any argument about aggravated assault applying because they can't get over the first hurdle. The first hurdle is it has to be charged. It's not charged. That's what the case law says. I mean, this is pretty clear to me unless I'm looking at it wrong when it says this is not to be given if there isn't an independent forcible felony charged.
Any other response,
I
Steve?
seem to agree with the defense.
Just said it defeats the purpose of the statute and is manifestly unjust when it is a legal technicality of no import. There is no interlocking verdict required. If we were able to charge aggravated assault, there's no requirement that they both be found guilty. They could go ahead and hear this instruction and find her not guilty of aggravated assault and still convict her of second-degree murder because of all the plethora of permutations we have in this instruction.
But in Martinez, the underlying charge was attempted murder and aggravated battery, both of which were charged, and we don't have that here.
But it's still going to the one act in those facts. We are talking about separate, clearly distinct facts here that support there's an aggravated assault that separately gets committed first, and then in response to the victim responding to that aggravated assault, she leaves him in the chokehold to die because if she lets him out, it's her belief she's going to face death or great bodily harm because she committed a forcible felony against him. This is purely a legal technicality. The entire opinion on Martinez, until the very last paragraph, uses this language.
I don't think the prosecution have a very good argument for this. If there's
They
no
use language like the underlying facts of the present case demonstrate why it would be illogical to conclude that section 776041 paren 1 applies where there is no independent forcible felony. It doesn't say where there is no independent forcible felony charged. It goes on and uses that same language all throughout the opinion, and then in the very last paragraph in the conclusion, it changes to, in conclusion, we hold that it is error for a trial court to read the forcible felony instruction to the jury where the defendant is not charged with an independent forcible felony. But there is an independent forcible felony in the facts. There is a statute that says that Ms. Boone should not be able to get the avoid the girth of this jury instruction. She violated, according to the facts that she gave us, she violated 776041 paren 1. She was committing an independent forcible felony and therefore should not be able to get away with this instruction not being given because the technicality that the state can't charge a case or can't charge a count that is not required to be interlocked by verdict. Thank you.
Okay. Footnote 4 provides explanation in the Martinez opinion as to certain circumstances and whether or not in that hypothetical that the Supreme Court gave, whether the robbery is a separate and independent forcible felony and the forcible felony instruction is applicable. But the conclusion seems to state that it has to be charged, that it is an error for the trial court to read the forcible felony instruction to the jury where the defendant is not charged with the independent forcible felony.
They're trying to determine whether or not an instruction.
Anything else, Mr. J?
And it looks like this one is not.
Then how do we want to accomplish this? Because I don't know how I can read the proposed language by the state. And there's a disagreement as to whether there's a duty to retreat. It's not undisputed. It is, in fact, disputed.
Well, their complaint is in the sentence, on the other hand, if at the time Sarah Boone used deadly force, she was, and I just think we strike through committing an aggravated assault. If at the time Sarah Boone used deadly force. Okay.
The female law students are gone. I just see the two dudes. Oh, wait, no, one of them is there.
And unless you just want to go to 2, on the other hand, if at the time defendant used deadly force, she was not in a place where she had a right to be, then the defendant had an obligation to, or excuse me, then the defendant had a duty to retreat. Just excise 1 completely. I don't know what else to do.
But she has a right to be there.
Right. Under the Castle Doctrine and the case law.
Okay, then I think we go with the first paragraph and then we just deal with the initial aggressor at the end, which is kind of the exception to that. So
Okay, so then Sarah Boone had no duty to retreat before using deadly force.
Yes.
Okay, is that acceptable to the defense?
Yes.
I think it puts us back in the position where we started at anyway.
Yes.
Okay, all right.
No duty to retreat before using deadly force. That's a win for the defense.
For the record, in case some assistant attorney general wants to potentially prosecute.
Objection noted.
Margaret Tier says, in my opinion, because she's so domineering, I think she.
It looks like the next parts of the form instruction,
And
if the defendant was in a dwelling, was excised, the give A, B, or C was excised. Are you on board with that state?
Pure evil rotten.
Then the next paragraph, a person is not justified in using force to resist an arrest. Clearly, that's not applicable. I don't think that's at odds. However, if an officer used excessive, I also don't believe that's applicable based on the facts. We then proceed to the give in all cases language. Any objection to this language state? Sure. The bottom of page 2 of the defendant's 3.6F red line.
I'm just finding where it's in
On the form instruction, it's the bottom of page 3 of 7. Given all cases, right after Jackson v. State.
Yeah, just the agreed upon strike terms of or threatened use. So just being deciding whether Sarah Boone was justified in use of deadly force, you must consider the circumstances at the time.
Any objection?
No objection to that, Judge.
We'll excise the threatened use, so it'll all read use of deadly force in that paragraph.
No, I don't think so. Should Zurenard, I don't think so.
Now we have a proposed instruction, I believe, from the defense regarding battered spouse.
We table the battered spouse proposed instruction since both parties have that.
Sure. Moving now to the presumption of fear, that's been struck out by both parties and agreed to. Moving to the exceptions of presumption of fear, that's been struck out by both parties and not necessary. That takes us to a person who unlawfully by force enters or attempts to enter, that's not applicable. Definition of dwelling is not applicable. Residence and vehicle are not applicable. That takes us now to the aggressor language.
Ooh, this is going to be good.
No additional arguments as to why the facts show she was the initial aggressor, and thankfully for the state, there's no requirement under this provision that there be an independent forcible felon.
Okay. Looks like we have a disagreement between the parties as to the application of the aggressor instruction. It's struck out on the defense's side and not in the state side. What say you, Mr. Henderson?
Give me 1 second.
Sure.
Please.
Yes, sir.
Owens is preparing for closing. Closing is going to start in about 90 minutes, just under. Well, after the reading of the jury instructions. Sorry. So closing will begin in about maybe 2.5 hours. I think they did it off calendar, Mimi. This one is a little bit more complicated. I think Florida has very complicated jury instructions. It's very specific. But then the Karen Reed case is a little bit different. Every case is different. And every state is different. Kentucky has very short. Rebuttal is done, Joe. Rebuttal is done. The case, all the evidence is closed. 100% of the evidence has been submitted by both parties. And we're on 100%. The case is going to be submitted to the jury.
We're
going to have a verdict tonight.
041 sub
Maybe.
2.
Probably.
Yes, sir.
Okay. If I could have one more.
Yes, sir.
Jen says, again, these are all opinions. Just like Margaret thinks she ordered him into the suitcase. Jen thinks Sarah dared him into the suitcase. Anything's possible. We don't have the other side. All we have is a biased witness who cannot be trusted.
Judge, my argument would be that the only evidence, well, the evidence from Sarah Boone stated that she did not do anything forcefully wise until after Mr. Torres had made verbal threats and was coming out of the suitcase. So that's my objection is based on that. No other legal argument.
Any other argument, state?
Just judge, it's play wrestling and not releasing the chokehold when your buddy tapped out.
And I mean, isn't there evidence as to what Ms. Boone had told the experts, which seems to be at odds with that issue? And it's really a factual issue and a determination for the jury to make that determination on what the real facts are.
I can't disagree with that.
Okay. Then with regard to the proposed language as the 776.04141 sub 2 instruction. However, the use of deadly force is not justified if you find that Sarah Boone was attempting to committing, or escaping after the commission of aggravated assault. An aggravated assault is defined.
No.
No.
That's the friend one.
Am I on the wrong section? I apologize. I am at the wrong section. Forgive me. So it is the, however,
My strike throughs is, however, the use of deadly force
is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself unless, one, the threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on George, that's spelled incorrectly, Torres, or two, in good faith, Sarah Boone withdrew from physical contact with George Torres as clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force, but George Torres continued or resumed threatened use of force.
Yes, sir.
What's your, just for clarification purposes, anything else as to that instruction defense?
Just one thing I need to put on the record, Judge.
Yes, sir.
The force at that time, as testified to, was the poking of the bat on the outside of the suitcase. There was one strike when the hand was outside. These were bruises. I think there was something that came to the injury to the head area, though. The injury to the head could be serious, but in this instruction, it's talking about deadly force. And none of those, as to the X-ray, as to the testimony from the medical examiner, none of those injuries caused the death.
But the continued restraint on him that she did not undo is the force that we're talking about. It's just like in the cases that I cited in my special state's request for special jury instruction regarding withdrawing from physical contact. Batteries don't need to be skin to skin. You can commit a battery on somebody while driving your car and striking their car. A false imprisonment does not mean you have to choke somebody. You can falsely
The jury is
imprison
at
somebody
lunch.
by barricading them into a room.
Closing,
a grocery cart.
reading of the jury instructions and closing.
Unlawfully exerted that force and did not withdraw from using that force when her wrestling partner, so to speak, tapped out.
I'm going to include the instruction for now. The next paragraph reads, if you find that Sarah Boone, who, because of prior threats or difficulties,
No objection.
all right, that'll be included. The next paragraph, if you find that at the time of the alleged aggravated assault and or criminal mischief,
Yeah, there just needs to be secondary murder, manslaughter, or culpable negligence, and we don't object. There were specific acts put in evidence.
any objection to changing the beginning of that sentence defense, if you find that at the time of the alleged murder in the second degree, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act.
Yes.
Okay, thank you.
And we requested the strike through at the end or threatened to use.
Agreed.
Give me a moment. So that sentence would now, or that section would now read, if you find that at the time of the alleged second degree murder, manslaughter, or culpable negligence, Sarah Boone knew that George Torres Jr. had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Acceptable?
Yes, sir. I just don't know that we used Junior after his name anywhere else.
Give me a moment. Yeah, Junior's not used anywhere else, so I'll excise that. Is that acceptable to you, Mr. Henderson?
Yes, Your Honor.
All right, moving to the next line. If you consider that George Torres, removing Junior, had a reputation for being a violent and dangerous person. I don't know, did we hear evidence of reputation?
The state's position is going to be there was no reputation evidence. Ms. Boone offered an opinion, but as everybody knows, reputation evidence has to come from a broad enough aspect of the community, whether it be a church or a neighborhood or perhaps even a large family. But
Defense?
I'm rethinking that, Judge.
No worries, take your time.
I know generally, and reputation evidence, generally, it has to be something that is known based on a community standard, and if that was the community. I know the only thing that I can relate to is the fact that individually, she experienced certain things that could build that reputation, but that's on her. I think there's evidence though from people, at least that they knew about it or were told about it, most of that was stopped. But I could go to at least the one situation on a text message that was introduced earlier today that talked about him beating his former wife or ex-wife.
How's that reputation? That sounds like that's a specific instance based on that text message.
I agree.
Okay, so in agreeing, we're going to excise the reputation section, correct? Okay, thank you. The court will excise that.
I love how he makes such a lengthy argument. He's like, yeah, you know what, never mind.
What about the one that precedes that? If you find that George Torres had a reputation, well, also that reputation would be removed as well, correct, Mr. Henderson? If you find that George Torres Jr. had a reputation for being a violent and dangerous person, you may consider this fact in determining whether he was the initial aggressor.
That's correct.
Okay, so that'll be excised as well. State has no objection to the physical ability section. I'll just remove the word junior after Torres. Any other questions with regard to the 3.6F instruction?
Your Honor, state doesn't object to what we have produced as the final product. I'm impressed we did it so quickly. We just note our objection for the record to preserve a challenge to Martinez.
Understood. Do the parties, well, let me ask this question. Mr. Henderson, anything else we need to address with regard to the 3.6F instruction?
No, sir, I'd just like to preserve the objections that I made during this conference.
Objections preserved. Do the parties wish the court to reread the 3.6F instruction that we just went through, just to make sure we're all on the same page?
Yes, sir. Can we do it at a time where it
Is in final form? Yeah,
Yes.
absolutely. Okay.
Perhaps a written copy that we can take during snack time.
Sure, absolutely. All right. Where does that take us now? Does that take us to the 3.6G instruction?
I believe so.
Okay, give me a moment. I have state's proposed 3G instruction. I have the form instruction from the Supreme Court. And I have the defense's proposed revisions. Just move everything around here. Give me a second. Okay.
I'm curious, Thomas, are you familiar with, talking to Thomas Fisher real quick, are you familiar with the concept of believe all women that Vogue posited during the Johnny Depp trial? I'm curious if you subscribe to that theory.
All right.
Do you think we should
As to the
believe all
title,
women
I
regardless
believe
of...
that based on what we've discussed, the or threatened use should be removed. Is that correct?
That's correct.
All right.
Well, just, should we believe all women? Let's just say that. I'm curious. You don't? Okay.
As to the first sentence, it is a defense to the crimes of second-degree murder and culpable negligence if the actions of Sarah Boone constituted the justifiable use of threatened use, as we're removing justifiable use of non-deadly force. Would we be removing threatening, and we would also be including manslaughter, correct?
That's correct.
State?
Yes, sir. It is a defense to the crime of second-degree murder, manslaughter, in Oxford, or culpable negligence if the actions of Sarah Boone.
That's Susan.
I too am a big fan of the Oxford comma. So the defense would, or the instruction would now read, it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use of non-deadly force. Acceptable state?
Yes, sir.
Acceptable defense?
Yes, sure.
Definition of non-deadly force is not at issue. Next paragraph. Sarah Boone does not have the burden of proving that she was justified in using non-deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using non-deadly force. Acceptable state?
Yes, sir.
Defense.
Yeah, sure.
The law on justifiable use of non-deadly force is as follows.
Yes, Charlotte.
Sarah Boone was justified in using non-deadly force against George Torres, excising Jr., and had no duty to retreat if she reasonably believed that such conduct was necessary to defend herself against A, George Torres, excising Jr., imminent use of unlawful force.
Oh, and
Is that instruction acceptable?
Yes, sir. I don't know if you mean to include the A if we're not using the B. I would just suggest you make one sentence.
Any objection?
No objection.
Any other issues with the instruction as read so far? State.
No, sir. Thank you.
Defense.
None, Your Honor.
Okay. Looks like there are several agreements with the balance of this instruction as to the defense of property is not applicable, the 776.0134 dwelling in residence and vehicle, and force with regard to law enforcement, all of which is not applicable in the instant case. That takes us to the give in all cases. We would be removing the threatened use of non-deadly force in that section. Any other changes is to the give in all cases section.
Nothing to say.
Defense.
None, Judge. No objection.
I like the way this judge runs this courtroom. Very tight ship. Auntie Beverly Canoni could learn a thing or two from.
Let's table the proposed instruction on the battered spouse for the moment.
Then the state will be making its request for the forcible felony instruction.
Under Martinez.
Yes, and we understand the court's ruling, and we're sending a strongly disagreement to the court's report.
Received and understood, but based on what the court said earlier as to the conclusion in the Martinez section, I'm disinclined to add your proposed instruction. That takes us now to the 776.0412 section. Looks like we have a little bit of a disagreement here. Is it the same arguments that we received in the 3.6F instruction?
It's the same fact.
Any other additional arguments, sir?
No, Your Honor.
All right, for the reasons previously identified, the court will accept the state's proposed portion as to the 776.0412 instruction. Then it takes us to the prior threats.
Same requests and objections as in 3.6F from the state, sir. For the end of the instruction.
I agree that it should track with the,
Forgive me. Other than reputation, what were the other issues?
Prior threats should come in.
Mhm.
Specific acts should come in.
Okay, thank you. Reputation should be excised.
The two paragraphs of reputation excised, and then physical abilities gets read in all cases.
Agreed?
correct.
Okay,
Agree.
all right. And then we'll remove the threaten language in there, correct?
Yes, that's correct.
Okay. Any other questions with regard to the 3.6G instruction state?
No, thank you, sir.
Defense?
None, Your Honor.
Okay. I believe then, just double check my notes.
So that's a fascinating question, Thomas.
I believe then that addresses those issues based on what we did not discuss this morning in the charging conference.
Is there a scintilla of evidence?
Requests in the.
I don't think there has been.
Special instructions.
But the problem is we weren't there.
Conflicting requests.
The jury
Yes.
could theorize. You know, juries can insert facts not in evidence. but they
Specifically, we're making reference to the state's request,
as scary as it sounds, it's
special
100% true.
jury instruction regarding battered spouse syndrome filed, I believe it's not dated, but I think it was either
A
yesterday,
jury
it was
can
either the
make
23rd or
up
the
facts
24th that you filed
if
these.
they all believe that something
Mr.
did
J, and the
happen.
court record will speak for
Amen.
itself as to when they were filed.
Sounds scary, but it's true.
Okay. Courts reviewed that motion and reviewed the proposed instruction by the defense. State, let me hear from you first.
They could infer.
With their
Oh,
instruction, I think.
Let's open that can of worms real quick. That's a fascinating question, actually. Where is it? Not this one. This one. There is absolutely no evidence that we heard in the record that she put him into that suitcase and like forced him in or ordered him or taunted him or whatever. But I, as a juror, after listening to everything, I could go back and say, I don't believe her. She's a biased witness. She's a non-credible witness. I don't buy her testimony. I don't believe she is so innocent here as she makes it out to be. I, as a juror, believe blah, blah, blah. And that blah, blah, blah could be, what if she like ordered him as punishment, get in the suitcase? So I, as a juror, can go back and be like, look, the defense didn't talk about it. The prosecution didn't talk about it. Sarah didn't talk about it. But I personally, as a juror, believe it's possible based on her conduct, based on her prior acts, based on the videos that we've seen, based on the suitcase video. Jurors are permitted to assume facts not in evidence. It's called jury nullification, reverse jury nullification. It's where you find someone guilty based on everything surrounding the facts. Just like jury nullification is, we don't like this law, so we're going to acquit the person. You have reverse jury nullification. This law that they're charging her with is not strong enough. We want more. Because blah, blah, blah. Yes, that is a real thing. Jurors are permitted to do that, and there's no way to stop them. Because jurors are members of the community, and they get to determine, they're the triers of fact. They get to determine what happened. They're the best arbiters of the decision. We know for a fact he was not capable of zipping himself up. He even tried to escape, according to Sarah, and she shoved him back in using a bat, like New Text 1954 is pointing out. He did not zip himself in, right? He says, same as he got in an old fridge and she locked the door. All right, let's keep watching. Let's see what we've got here.
And read it. Do we want to have the title special instruction on battered spouse? I welcome.
I'm fine with just saying battered spouse syndrome. That's
Okay, so it'll be special instruction on battered spouse syndrome. Is that acceptable?
Yes, sir.
Is that acceptable?
Yes.
All right, thank you. All right. And that will follow after the 3.6G instruction, correct?
Yes, sir.
Acceptable, Mr. Henderson?
Yes, sir.
All right, that takes care of that. Yes, I'm sorry, sir.
I'm sorry. I think we might be required to read it both times after each one.
I have no problem with adding a paragraph into it that says this applies to both the justifiable use of deadly force and non-deadly force.
That's fixed.
Okay. Where, gentlemen, do you want that?
After the big paragraph that ends with Jorge Torres and before like any other witness.
Sure. Okay, so let's go over that language one more time so that we're all on the same page. Mr. J, what is it that you propose?
To put between the paragraph that ends with Jorge Torres and before the paragraph of like other witnesses, whatever I said.
Mhm.
You can consider this testimony and evidence in the applicability or the use of whatever word people agree on of both deadly force and non-deadly force instructions, something to that effect. If that's too convoluted, I'm fine with it just being repeated.
I tell you what, I'd rather just repeat it.
I think so.
That gets way complicated.
Yes.
I'd rather just repeat it under 3.6F and 3.6G.
Agreed.
Okay. Does that work with you, Mr. Henderson?
Yes, sir.
All right, thank you, sir. All right. Okay. Moving now to the state's request for special instruction regarding withdrawing from physical contact filed October 23, 2024. The court has reviewed it. I guess the first question is, is there proposed language?
Trying to see if I'd actually put that in there.
I don't know that I see it, Mr. J.
Oh, paragraph 15. Physical contact includes any restraint on George Torres, apostrophe, movement.
And this would be after the initial aggressor portion in the 3.6F and 3.6G, correct?
Yes, sir.
Okay, what say you, Mr. Henderson?
If I can have one.
Yes, of course.
They're not going to get a lunch, are they, at this rate? It's already 12:30 and the jury's ordered to come back at 1:30. There's only an hour left for lunch.
Judge, this is what I'm having a problem with, but I think it could be corrected.
Mhm.
Because they're talking about it as, therefore, at the conclusion of the two paragraphs regarding initial aggressor, it should come in not there, but shouldn't it come in because that's not there anymore? Initially provoked.
Yeah, in the 3.6F instruction, references to initial aggressor have been removed.
Yes. So now is the state asking for it to come in as the initially provoked?
Unless I missed something.
My understanding was that it was the two paragraphs about aggressor are coming in What's not coming in is the Martinez forcible felony. The facts of the case.
Right, but the language, you said at the conclusion of the paragraphs regarding initial aggressor, the words initial aggressor don't appear in the 3.6F. It's only after that. However, the use of deadly force is not justified if you find Sarah Boone used force to initially provoke the threatened use of force against herself unless, and then it's paragraphs 1 and 2.
No, I'm talking about
Is that where you're asking it to be?
the lawyers are hungry too, not just the jurors
Sure.
and the judge. Everybody's got to eat.
3.6F.
Mm-hmm.
It should be, however, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke
Correct.
the
That's what I
threatened
have.
use of force against herself unless, parens 1 and 2.
Correct.
And then after 2, as an explanation for what is listed in paren 2 as from physical contact, just that elaboration of what we're talking about.
I got it.
Because
Okay.
the unique circumstances of this case, the remote force.
Okay, I got it. I just want to make sure we're all on the same page as to where. What say you as to the proposed language of physical contact includes any restraint on George Torres's movement as that portion in 3.6F and in 3.6G?
No.
Okay, all right. So court's going to grant the state's request for
Oh, it's
special
just uses.
instruction
This is-
regarding withdrawing from
This is
physical
100%.
contact. And the language of physical
All-
contact includes any restraint on George Torres's movement will be included after the,
Nobody's
however,
falling.
the use of deadly force language after paragraph 2 in the 3.6F instruction. And in the 3.6G instruction, it will be at the end.
They're simply trying to make sure that the jury instructions are exactly the way that they should be presented to the jury, that the prosecution is happy with it, that the defense is happy with it, that the court is doing the proper job. This is normal. 100% normal. Nothing unusual here.
Oh, I'm sorry. You're correct. I apologize.
No problem.
Standard procedure.
Okay, got it. That takes us now to the state's request for special jury instructions on causation, filed October 23, 2024. I have reviewed it and the proposed instruction on paragraph 3 therein.
Judge, the reason we're bringing this up is just during the cross-examination of Dr. Z, or Zadovich, we poked the bear a little bit about his cardiovascular condition. My memory of the testimony was that she's emphatic that that was not the cause of his death. But because of that, and because of now the request of culpable negligence at misdemeanor for a lesser, I feel it might be warranted to give this explanation of causation in the second-degree murder and manslaughter instructions.
Interesting.
Defense, what say you?
Judge, I would object. I believe that just the instruction, the proposed instruction that I have it as one, but for the defendant's criminal act, which we have a standard jury instruction that said the death was caused by the criminal act of the defendant, and that's what they're required to prove. This language, to me, would lessen that requirement by saying, but for the defendant's criminal act. Then the second part, when it goes up to George Torres' death, was not beyond the scope of any fair assessment of the danger created by the defendant's criminal act. I think that's covered, Judge, in the fact that the state does not have to prove that Ms. Boone had the intent to kill George Torres. So that makes it confusing to me when the standard instruction basically simplifies it in my mind, and it keeps them right where they're supposed to be with that instruction. They don't have to prove that she had the intent. then as to the third part.
I'll just put on my request for that.
Okay.
If heart disease gets brought up in closing.
All right, fine. So withdrawn. Court takes no action on the state's request for special jury instruction on causation. That leaves us now with the state's request for forcible felony instruction and request for initial aggressor instruction. That's already been addressed, has it not?
I was just treating it as a special jury instruction for my argument.
Understood. All right, are there any other instructions sought by the state at this time?
I believe we have concluded this exercise.
Defense.
No other ones.
All right, here's what I'm going to do. I'm going to take all this upstairs. I'm going to re-review it. I'm going to merge it all into one document, and I will send it to all the parties. Let's plan on being back here at 1:30, and we'll address any other concerns of the jury instructions at that point in time. State, anything else we need to address?
125.
Let's make it 1:20.
All right, thank you.
All right, defense.
Okay.
Nothing else.
All right, we'll see you all at 1:20. Thank
You
you.
get some time to eat some food, which is good. They desperately need it. It's been a very long morning for all of them. They started early. They started like 8:30 or something like that. And it's already 12:40. I mean, to go for 4 hours like that without food is I imagine is a bit cumbersome with just one short break, which you could probably sneak in like a protein bar or something, but no more than that. 1:20, they're going to come back. They're going to finish up any jury instruction arguments. I'll be back at 1:30. I have a stream already set up. You guys are going to be pushed into it once I conclude this one. The jury instructions are going to conclude. They're going to read the jury instruction arguments in conference. I mean, is going to conclude. They're going to present the jury instructions to the jury around 1:30, 1:35, 1:40, whatever, however long it's going to take for them to finish arguing and sorting out all the instructions, making sure everybody's on board, defense, prosecution, etc. And then the jury's going to go back to deliberate. Well, sorry, they're going to read the instructions, closing arguments, and then they're going to go back to deliberate. So I imagine they're going to start deliberations maybe as early as 3:30. So in about 3 hours or so. So let's see. Let's see the closing arguments. I'm very excited. I'm very, very, very excited. This has been a very fascinating case. Everybody thinks she's going to get convicted for the most part. We have... What's the poll at, by the way? Let's take a look. Where's the poll at? If you guys haven't voted, go vote in the poll. It's on YouTube and on Twitter. 77% of you voted. You believe that she acted with evil or wicked intent. And 23% believe she acted recklessly or negligently. And on Twitter, X, about the same. 79% said out of 278 votes. So we have a total of what? We have a total of 278 plus 430. About 700 people voted collectively on both platforms. I'm sure there's some overlap. So we'll call it 600 just to be generous. And about 4 out of 5 people are saying it's going to be murder. Only 1 out of 5 people are saying manslaughter now. Since the percentages of people who have been saying culpable negligence and not guilty are so slim and so small, about 10% total. So we can shave off another 10% if you want, but for the most part, murder. Everyone's saying murder too. The overwhelming majority. Pure evil. So we'll see. All right, folks, we'll see you in about 45 minutes. Enjoy your lunch or dinner or breakfast, wherever you are around the world. Bye.